But questions, my lord, at page 1 to 3, my lord, the page number 8. Because it amounts to commercial
activity. Mr. Arvind is a vast expression, right? A wide expression. Then it has an inclusive definition that includes education also.
It amounts to commercial activity, my lord, is imparting of education, my lord, no doubt, my lord, it is a charitable activity. My lord, indulging into, my lord, cash transactions, my lord, and commission payments, my lord, to the agents, my lord, for getting admissions.
This number 2.
One and two.
But there are some the violation of payments, my lord, to the personal accounts, my lord, of the directors. That would be in violation of 11.5, my lord. That is, my lord, the question number 4. That would be relevant, my lord. 1, 2, and 4, my lord.
4. 1, 2, and 4. The KV Arvind? Yes.
But the controversy, my lord, here, my lord, the assessee, my lord, would be entitled, my lord, for, my lord, the first question, my lord, dealing with, my lord, the weighted deduction, my lord, of more than 100%. My lord, in respect of expenditure, my lord, incurred for research and development activities. My lord, there is no dispute about the assessee eligibility. The dispute, my lord, is the computation. If the process of R&D, my lord, if they are, my lord, earning any income, my lord, the expenditure should be allowed, my lord, on gross or net, my lord, is an issue. My lord, the body which has given a certificate of research and development, my lord, has clearly said that, my lord, what would be allowable, my lord, under the Income Tax Act, my lord, is the net expenditure, not the gross. Whereas in other cases, my lord, assessee says, my lord, whatever, my lord, that the scientific body, the special body says, my lord, that is final, and assessing officer has no power, my lord, to tinker with that. Question 1 and 2, my lord. 2, my lord, is on bad debts, my lord.
Yes. 3.
Let the transfer pricing matter, my lord, question number 1 to 4, my lord.
No. 1 minute. Yes, sir.
That serial number 4, my lord, the assessee, my lord, is a Karnataka Cricket Association. My lord, when the surplus profits, my lord, have been generated, but whether that is hit by, my lord, section 215, my lord, as well as section 11.8, my lord, the 13.8. The 13.8, my lord, says if the assessee, my lord, is a charitable trust, my lord, and entitled for exemption. My lord, if any income, my lord, which has the partake the character of, my lord, commercial activity for profit, my lord, that gets disallowed, my lord, under 13.8.
Right, so 1 and 2.
Lord, it is on different aspects, my lord.
The same
4 also may be relevant.
4 also. You have already 3 is in fact a duplication of 2, Mr. Arvind.
Please, my lord. The 4 would be relevant, my lord. Maybe the 1, 2, and 4 may be, my lord, relevant.
1, 2, and 4. Right.
Lord, 5, my lord, again, it is a royalty, my lord. Yesterday, lordship adjourned it, my lord, by 2 weeks. Awaiting, my lord, the review outcome of review petition, my lord, before the apex court.
Again, the issue involved in this appeal, a review petition is pending before the Supreme Court. For adjournment just after 2 weeks.
Lord, the 6, my lord, is Lord, 206A, my lord. If the payee does not provide for, my lord, the PAN number, my lord, as per section 206A, my lord, higher rate of my lord, TDS has to be made. Whether those provisions, my lord, are applicable, my lord, to the payments made to the non-resident company in view of, my lord, the double taxation avoidance agreement or not, my lord, is an issue. My lord, in fact, my lord, these issues, my lord, have been admitted by this honorable court, and few matters, my lord, were there in the final hearing list also. Let's kindly consider Malad to admit it, Malad, and issue notice. And in the meantime, Malad, I'll prepare that list, Malad, and I'll request your lordships, Malad, for final disposal on that. Question number 1 and 2, Malad.
Appear for appellant, my lord. Your lordship, in this case, my lord, the tribunal has set aside the assessment order on the ground that the assessing authority has not followed the directions issued by the dispute resolution panel as required under section 144C10, my lord. The tribunal at page number 12 has followed its earlier order, my lord, which has been challenged before this honorable court in ITA 339 of 2019, which is admitted, my lord. Question number 339 of 2019, my lord. Question number 1 and 3 may kindly be admitted, my lord.
Yes, on the question of admission 1 and 3. This along with ITA 339/2019.
My lord, I am appealing for the petitioner, my lord, in this matter. My lord, this is a habeas corpus petition, my lord, filed by the petitioner to trace out our missing husband, my lord, where missing complaint also been filed, my lord, which is an annexure A.
How much time do you want?
Even the representation was given to the third respondent that they are not given proper inquiry.
Government advocate says he will file the return, and this is your first information report has been registered missing. Maybe it may not be the proper remedy. We don't know what should you do. This is government advocate. Grateful is granted 2 weeks time to enable him to file opposition. 2 weeks, Mr. It's on 15th February 2020.
Number 9, Sri Joseph Anthony.
So this can be
appear for the appellants in serial number 9.
We will hear you day after tomorrow. Day after tomorrow.
Your lordships, 2 weeks time may kindly be granted. We'll pray for 2 weeks time.
Yes, all right. Now, Mr. Joseph Anthony, learned counsel for the appellant, pray for adjournment just after 2 weeks, 9 to 30.
Number 14, Sri Prakash Shetty here.
Pledge, lordship.
Yes.
Prakash Shetty.
Let me comply with office of this.
My lords, I have the serial number 14, my lord.
What recall? Huh? For the sending I gave you of 21. Duly supported by an affidavit order dated 20th September 2021 is hereby recalled in the result CEA number 10 of 21 is disposed to file accordingly I is disposed of. Then say 1 of 21 is dismissed as not present.
Number 16, Sri Raghavendra Ji Gayatri.
My lord, I appear for the petitioner. My lord, I appear for the petitioner. My lord, I need some time. My lord, kindly have it after 2 weeks. My lord, I'll get ready for final argument itself. My lord.
Lord, may I submit? Yes.
To kindly grant 2 weeks time, madam. I'll get ready in the matter.
What ready? Vacating his stay, you have to.
No, he has filed in vacating IA and also objections. I have sent it to the bank, my lord. I'll get instructions and I'll finally get it ready, my lord.
Yes, what do you say, counsel for responding?
Lord, for adjournment, I have no objection. Only thing is that there has been a change in the settlement clause, wherein they said that even in the case of cessation of work, my lord, due to absence, they are entitled to get the terminal benefits, my lord. If they can consider that, and in 2 weeks, let them consider it.
No. I will get the instruction for that. That's all.
Precisely for that reason, I am saying that let them consider in the light of the new settlement.
Don't know what is considering this. He is praying for time. For a consideration. Please argue with on the next date.
Next date, I'll definitely argue.
Please,
counsel for responding. Counsel for the petition, pray for adjournment. This on 14th February. 14th February.
Please,
2020.
much of.
14.
I think the Ramesh here.
Malad, in this matter, I appeal for the petition in this matter. Malad, I appeal for the petitioner in this matter, my lord. Malad, in this matter, Malad, there were
Which case?
two.
17.
Please, Malad, there were two appeals dismissed by this honorable court. Malad, the accident took place on account of the negligence on the part of the driver of the lorry. Malad, before the Supreme Court, Malad, in one of the appeal.
It got dismissed here. We did not go to Supreme Court. The other person who was dead, his family went to Supreme Court. Supreme Court set aside the High Court order. Parity is as one for three.
Mr. Ramesh K.R. Learned Counsel for the petitioner in notice of IA 1 of 22.
We are Om Kumar, we are Aslam Khan. I think the Narayana Yamar.
Serial number 19, I'm appearing for respondent number 3, please, my lords.
I appear for the respondent number 2.
For respondent number 1, my lord.
My lords, a statement of objections was sent by register courts to the counsel appearing for the petitioner. However, my lords, it has come back saying that no such person in that address. The address which was furnished in the writ petition, we have sent it. I have also, my lords, affixed the receipt.
We'll have to find out.
Please.
You are appearing for which respondent?
Second respondent.
Learned Counsel for respondent number 2. Prayer for him is granted a week's time to enable him to serve a copy of statement of objections on counsel for petitioner.
Please, oblige.
Lord, I am appearing for the petitioner, my lord. I have filed a NOC Wakalat, my lord. My name is not showing in the cause list, my lord.
To argue, no.
My lord, I request.
It will be decided today, so there will be no question of showing your name.
My lord, I have not prepared for the case, my lord. May kindly have it on Monday, my lord.
Be prepared.
My lord,
You will be prepared only when your name appears in the cause list. Huh?
No, my lord. For
When
now,
do you want?
my lord.
When
My
do you
lord,
want?
Monday, my lord.
Need counsel for the petitioner praise for adjournment.
And name may kindly be shown, my lord.
Office is directed to reflect the name of this so-and-so. You should be cautious, Mr. Nowadays. Huh? You know that the proceeding is being live streamed. Huh?
My lord,
and in public view, full public view, you are saying that you are not ready. And supposing if your client is watching you, then what happens?
sorry, my
For
lord.
you too. This live streaming thing is a double-edged weapon, right?
Please,
Be careful.
my lord, Monday I will get it.
Yes, Monday.
Serial number 20, my lord. I'm appearing for the petition.
I appear for the petitioner in this case, my lord. Whether the question involved in this case is
Appear for the respondent.
whether commission paid to the agents working in BPO would attract provident contribution, my lord. Whether it would be basic wages under Section 2B of EPF and MP Act 1950. Original authority, my lord, has passed order.
We just want to ascertain whether counsel for respondent is ready. So
My lord, we are sent for objection for the approval, my lord. I placed 2 weeks time, my lord. And order of the CJIT is partly allowed. We also challenging the order by filing the writ petition. The both the petition and the objection is sent for the
Mr.
approval.
Prabhakar later file objection.
Very well.
DC Prabhakar, learned counsel for the petition. What's your name, madam? Write your name.
Anjana, my lord.
Learned counsel for respondent case for his land taking time. To file objection.
Number 22,
For the petitioner, my lords. In this case, the violation of 25F of the ID Act, my lords, court has granted only 25,000 rupees as a compensation instead of reinstatement, my lords. Admittedly, the worker has worked from 1198 to 2002, my lords.
That's what documents have been produced?
My lords, in the evidence itself, they have admitted that I am continuously working. I take my lords to page number 68, my lords, cross-examination of MW1.
Let us first go through the findings. Report to para 7.
Yes, my lords.
Page 28.
Yes, my lords. Para 7. The question of regularization have been logically concluded by the orders of the High Court.
Come to page 28.
The cover of the petition is only about the legality of the stoppage of termination of the services of case Narayana so and so. They were
Come to the later portion of the at page 28.
Yes, and that later portion of
I have no other rule except draw adverse inference.
Yes, madam. First party has sought for wages paid, vouchers and the attendance register for the period from 1198 to 2002. Those documents are not produced under the protest that they are misplaced. That drives me to infer that they had worked continuously for the period from 1198 to 2002. The service seems qualified. The section 25B of the Act, they could not have been refused employment without following the mandated section 25 F of the ID Act. Removal. Cross-examination also clearly admits that I have continuously worked and directly employed under the management manner.
Not working.
So the finding is against you, Mr.
Finding is only 25,000 rupees compensation has been granted, my lord.
No. Finding is that you are not in employment for a period from 1st of January 98 till 14/6/2002.
No,
That's
no,
the
no.
finding there. Hey, it's a typographical error. Please see. Both sentences have to be read together.
My lord, sir, in the claim statement itself, I have stated and
And you are not you are a daily wage employee, right?
Yes, my lord. My lord, sir, just I will take my lords to page number 68, my lord. In the cross-examination, he clearly admits, my lord.
Yes.
My lord, sir, cross-examination. Whatever the awareness I have shown to in so and so, documentary proof. While the first party workmen were working at Bangalore, I was working in Chennai. There are documents pertaining to the engagement of contractor so and so. It is incorrect to suggest that the GDS Enterprises was engaged as a contractor. Thus, my affidavit awareness pertaining to the engagement of first party by GDS Enterprises is false. Maybe that case Narayana was appointed as a casual in December 94 directly by the second party. Maybe that Mahadeva was appointed casual in 15/9/97 directly by the second party. Maybe they were working under the direct control, direct supervision and control of the officers of Air India. The second party enterprises, it is incorrect to say that they were working attendance regularly. The employees of the second party were provided identity card to enter the airport premises. Maybe the both first party workmen were working inside the airport premises. It is that they were provided with identity card, the second party they enter the airport. It is true. They are paid wages by way of vouchers by the account department of the second party based on the number of days, so and so. It is incorrect to suggest that since their appointment, both the workmen worked continuously till the date they terminated without any break with the second party. I have not verified individual cards pertaining to the first party workmen as to whether or not they worked continuously till their termination. Based on the information given by the section in charge, I am stating that they have not worked continuously. Since the case is going from the 2000, in the year 2000, I used to get the information as and when required from the station in charge. That information is communicated by way of letters. Letters must be available.
No admission. We have read it. There is
Yes,
no
sir.
admission. Fine. That's all. Anything else?
That's all, my lords.
Thank you.
For admission, serial number 23, government advocate to CJ Kamath.
Your Lordship, I appear for the respondent.
Yes, madam.
Your Lordship, in this issue, the appellant have challenged the order of the Karnataka Appellate Tribunal, which arises under the Karnataka Value Added Tax Act, Your Lordship.
Petitioner, nobody, government advocate. What is mark the presence? It is stated at the bar that the arguing counsel that the matter has to be argued by Mr. Jeevan J. Neraki in this court. You walk over the submission. Let the petition be listed in the next week, madam. Next week.
Obliged, Your Lordship.
Mr. Narayan, counsel for the petitioner. But on the question of admission, in this petition under Article 227 of the Constitution of India, the petitioner has called in question the award dated 19/3/2020 passed by the central government in the Labour Court, so far as it denies the relief of restatement along with full back wages and other consequential benefits. Paragraph. Facts giving rise to filing of this writ petition in nutshell are that the petitioner was employed on a daily wage basis in the establishment of the respondent on 1/1/1998. Full stop. The services of the petitioner were dispensed with on 14/6/2003. Full stop. Thereupon, the petitioner approached this court to the relief of regularization as well as continuation in service. However, the bench of this court dismissed the writ petition. The petitioner thereafter approached the Central Labour Authority for conciliation and resolution of the dispute pertaining to termination of his service. The conciliation ended in failure, and thereupon an order of reference was made to the central government in this tribunal. Paragraph. The petitioner as well as respondent adduced evidence before the tribunal. The presiding officer, by an award dated 19th March 2020, inter alia held that termination of services of the illegal retrenchment. However, taking into account the nature of employment of the petitioner, which was temporary in nature, the tribunal declined to grant the relief of reinstatement as well as back wages and awarded a monetary compensation of rupees 25,000 to the petitioner in place of notice paid for 3 months. In the aforesaid factual background, this appeal, this writ petition was filed. The counsel for the petitioner, while inviting the counsel for the petitioner did not dispute the nature of employment of the petitioner, as well as the fact that he was engaged on a daily wage basis in the establishment of the respondent. However, while inviting the attention of this court to the cross-examination of the management witness, it is pointed out. Management witness, namely S.I.R. Swami, contended that the aforesaid witness in the cross-examination has admitted that the petitioner has rendered services for a period from 1998 to 14/6/2002, and therefore the relief of continuity in service. Therefore, the relief of restatement along with full back wages ought to have been granted. Paragraph. We have considered the submission made by learned counsel for the petitioner in paragraph 7 of the award. The tribunal has adverted to the evidence adduced by the parties and has held that no documents have been produced by the petitioner. No documents have been produced by the petitioner with regard to the period from 1/1/1998 to 14/6/2002. So, thus, the tribunal has therefore held that there is no material on record to infer that the petitioner has rendered services continuously for a period from 1/1/1998 to 14/6/2002. The tribunal has further held that the petitioner was a daily wage employee, and therefore, instead of granting the relief of reinstatement with full back wages, the relief of monetary compensation of rupees 25,000 has been awarded to the petitioner, which is in consonance with law. The order passed by the tribunal neither suffers from infirmity nor any error occurring on the face of the record, warranting interference of this court in exercise of supervisory jurisdiction under Article 227 of the Constitution. In the review of preceding analysis, we do not find any merit in the repetition, the same case and the hereby.
In D group, number 24, the Chaitanya Hegde, the Nagaraj Damodar.
Appear for the respondent in this matter, my lord.
My lord, I appeal to the petitioner. But the matter arises under the surface we have. And accepting my offer for one-time settlement, subject to return of the documents, the entire amount was paid, settlement amount, in March 2021. But thereafter, bank has failed to return the documents for one reason or the other. And only in somewhere in, it has issued the no due letter also in May 2021. But somewhere in November, first time, the bank says your documents have been destroyed in a fire accident in 2017 itself, which have not even disclosed in the statement of objection filed in the year 2019 by the bank. Now, my lord, I asked them to at least give a letter endorsement with all the relevant documents saying that such fire accident took place and you had filed a police complaint and Mazar and all. And also an indemnity saying that no, when the documents were in custody of the bank, no liability has been created. Till today, they are not giving it now. It is nearing 1 year, the amount has been settled.
This seems to be a fair.
The fact of the mishap of the fire accident has been already brought to the notice of the petitioners, my lord. And thereafter, the bank is also at the verge of obtaining the certified copies and also to issue a letter regarding the mishap which has been caused, my lord.
That's what he's saying.
That will do it, my lord. That will do it.
How much time?
My lord, since the documents were deposited there in Mumbai, And the communication, because of that only, there was a little time, my lord. But we'll
So
definitely
how
do
much
it.
time you will?
Maybe within 15 days, we will give it, my lord.
Not be present, there is counsel for the receipt. So you will give a letter that this their documents have been destroyed in this fire, and an indemnity to the effect that you have not created any this thing encumbrance in respect of
Prior to the issuance of the letter and the letterhead, my lord,
Yes.
I'll share the copy along with the petitioner's advocate, my lord. After they concur only, we'll issue that, my lord.
Fine. There is counsel for the petitioner. Case for him is granted 2 weeks time. If able him to send a communication to the petitioner informing him that the documents in relation to property in question were destroyed in a fire and no indemnity was created in respect of the property in question. It's on which date, Mr. 17th February or 16th?
End of this month, my lord.
You said 2 weeks. All right, 21st February.
Yes, ma'am.
21st.
Number 25.
And I appear for the petition, madam. There is.
Yes.
Madam, I appear for the petitioner.
Yes.
For appearing for the respondent.
I am appearing for the petition, madam. I cannot appear for the petitioner. Many of the fact, madam, I was the panel advocate in the Oriental Bank of Commerce. Now it is merged with Punjab National Bank. But I can't appear for the petitioner, and I have already informed him, and he has gone undergone an operation. Therefore, I request 2 weeks time, madam, so will come and appoint another advocate for his on his behalf.
We don't know. So and so learned counsel for the petitioner. Grace for him is granted 2 weeks time to enable him to seek instruction.
Number 26. Pawan GL, government advocate, Sri Arvankar.
Beg to appear on behalf of the petitioner, my lord.
Yes.
My lord, the respondent, they had taken time on the last date to file objections finally, my lord. Whether
they find it.
They have not served a copy yet, my lord. They said they'll be serving a copy in advance.
Arvankar.
He's appearing. Pass over. Mr. Shetty. Let's see.
Shashikiran, my lord. Shashikiran Shetty, my lord. I'm sorry, my lord.
We know you. We are only saying pass over.
Pass over, please, ma'am.
I'm
sorry, I didn't hear, ma'am. I'm sorry.
Other side is has not appeared. We are passing.
Please.
Number 27.
Appear for the petitioner, my lord.
For the respondent number 2 and 3, my lord.
My lords was kind enough to record my submission on the previous hearing date, that is on 10th of December, my lord. The question before my lords is, the KSFC has, without a valuation report, the manager himself has valued the property in violation of Rule 8.5 of the SURFACE rules and brought the property for sale. That was the first point. My lords was kind enough to record it on 10th of December. The second point is that as per Rule 9.1, my lord, 30 days time has to be given from the date of publication to the date of sale. Here only 6 days are given. The notice is dated 9/11. Sale takes place on 15/11. Sale gets confirmed on 20/11. And in the month of December, they even give a sale certificate. I have also furnished find a synopsis as well as giving the date, as well as 3 judgments my lords had recorded on the previous hearing date. That is also I have furnished for my lord's kind consideration. The DRT accepts my prior mail and sets aside the sale. DRAT says these are all too technical in nature and the purchasers are bona fide in nature. Therefore, I don't find any good reasoning of the DRT order. That is the nature of finding of DRAT. If I may kindly invite my lords to ink page 34, 33 and 34. This is with respect to second matter, my lord. May I request my lord to take up the second matter first? 25192. 25192. If I may request my lords to kindly see the second matter. ink
We
page
believe that,
33.
yes, counsel for respondent is ready, right? You are ready, no? Yes.
Srinath Kumar Bian, Sri Rahul
Lord.
S. Reddy.
Yes, I appear for second respondent, my lords. Learned senior counsel appears on my behalf.
I appear for respondent number 4 and 5, my lord.
So you are ready, no, Mr. Reddy?
Yes, ready, my lord.
Right. That's what we wanted to. Otherwise, at the end of the argument, somebody will say, who is the other person who is appearing with the headphone? Yes.
Lord, I appear for the second respondent.
Give it respondent number 1, my lord.
So you are ready, Mr. Whatever.
Yes,
we are hearing case now. It will not be adjourned now. Yes. Yes, Mr.
May I know?
Yes, please.
The DRT finds favor with my arguments, my lord. The principal contentions that I have urged, they are the three which I just mentioned to my lords. That is violation of Rule 8 subclause 5 of the SURFACE rules, which contemplates mandatorily that they have to secure the valuation report by the approved valuer. Approved valuer is defined under Rule 2, my lord. May I just take my lord to that? Rule 8.5.
Let us first see what DRT has held, what DRT has held. We will go to the submission.
Yes, madam. DRT order, my lords, would get at ink page 73, my lord.
Yes.
Annexure K. The reasoning starts in ink page 81, but my lords may kindly come to ink page 84. It's valuation report and the guideline value. My lords may kindly see ink page 84 from page line 10. Man. Valuation report has been produced, which has been issued by the manager of KSFC, who allegedly inspected and prepared the valuation report, stating that the sub-registrar rate of the property in question is rupees 21.13 lakhs and the market value is 35.60 lakhs. It is relevant to note that the measures and action in question initiated by the respondent 1 KSFC under the SURFACE Act, Rule 8 subclause 5 of the rules mandatorily prescribes that the authorized officer shall get the valuation report from an approved valuer and thereafter, in consultation with the secured creditor, has fixed the reserve price of the property and may sell the whole or any part of such immovable secured asset. In the case on hand, the valuation report produced by the respondent corporation has not been obtained from the approved valuer. It is relevant to note that the manager of the KSFC himself allegedly visited and prepared the valuation report. This modern procedure adapted by the respondent number KSFC cannot be approved under law. Mandatorily, as noted above, the respondent corporation shall obtain the valuation report from the approved valuer, and absolutely there is no provision to prepare the valuation report by the employee of the financial institution, that is the creditor itself. Therefore, the valuation report invoked by the respondent KSFC for fixing the reserve price of the impugned sale of the property in question cannot be accepted, as it has violated the mandatory rules which is referred above. Added to it, there is no concurrence from the KSFC for fixation of reserve price. Therefore, I feel that the impugned sale shall be set aside. That is on point number 1. Point number 2, that is para 16. It's about the notice, the gap of 30 days as contemplated under Rule 9.1, my lord. I may be permitted to read para 16. May I?
Yes.
The next contention is regarding service of demand notice. It is contended that demand notice has not been sent and served on the appellant for the guarantors and mortgages the property in question. Para 17, I may be permitted to read. The notice is also not served, but I am more on this sale notice itself. The next ground urge is regarding impugned sale notice. It is contended that impugned sale notice has not been sent and served on the appellants, and there is no 30 days clear sale notice. Hence, it is contended that there is a clear violation of the mandatory rules provided under the SURFACE rules, Rule 8 and 9 of the rules. The respondent corporation has produced a copy of the letter sent to the present appellant dated 10/8/2010, intimating that within 30 days from the date of sale notice, letter property in question will be sold. It is relevant to know that the respondent corporation has produced sale notice of the paper publication on 8/11/2010 bracket 9/11/2010, having published in the daily newspaper by name Hindu, Vijay Karnataka, and sale notice dated 10/11/2010 is also produced along with the postal covers, which indicate that they have not been served on the appellant, and it also appears that there is no compliance of Rule 8(6) as there is no notice of 30 days for sale of the property in question on the appellants. Added to it, it is also relevant to note that there is violation of Rule 8 sub clause 7 as there is no affixture of sale notice on the conspicuous part of the secured asset. Thus, there is clear violation of mandatory rules provided thereunder. Hence, it is to be held that the appellants have established that the impugned sale notice is illegal. Therefore, SCA stands allowed with costs. Kindly see the inference of the DRAT as against this, my lord, in page 33 and 34. May I read 32 last paragraph? Paragraph 9. That's the inference it starts. Paragraph 9, ink page 32. Admittedly, there had been valuation report produced by creditor, which is prepared by the manager technical, who was not the authorized officer who initiated surface proceedings. It is pertinent to note that no other report is available on record to show the market value of the property at the relevant time. In such a situation, when no other option is available so far as the valuation of the property is concerned, the report prepared by the manager technical of the bank who was not involved in exercise of the sale will not be treated as illegality, which is causing prejudice to no one. The main question is whether the property is undervalued or not. On record, no material is available to presume that property is undervalued. Next point. Insofar as the sale notice, it was published on 9/11/2010 and e-auction sale was conducted on 20/11/2010. It is pertinent to note this was the second sale notice. Record reveals the bank had issued first sale notice on 9/10/10, but bank could not succeed to attract any bidder on the basis of the said notice. My lord, it may be relevant for me to make a submission that this is prior to 2016 amendment. For after 2016 amendment, for the second sale, it is only 15 days that is required. Earlier to that, 30 days was mandatory. May I request my lord to kindly see in para 12. After having an operative stock of the acts and intention of the parties, it becomes clear that appellant auction purchaser is a bona fide purchaser as a third party. Non-availability of valuation given by the approved valuer and having a gap of less than 30 days in publication of sale notice and actual sale will not vitiate the sale in view of the facts and circumstances of the case, because respondents borrowers have failed to challenge the sale and sale certificate within 45 days and failed to make a deposit of due amount, sale amount before entertaining the appeal by the presiding officer. This is a factually incorrect, my lord. This honorable court had granted me permission in a writ petition with a copy of the order of this honorable court also have produced. This it is available at ink page 50, my lord. This honorable court had granted permission because those days DRT was functioning only 3 days. Therefore, this honorable court interfered with the sale notice and granted time and extended the time as well. Annexure G, ink page 50. That has not been considered by the DRAT. Kindly see ink page 54, last 3 lines. I find it just and reasonable to extend the interim order granted for a further period of 4 weeks, reserving liberty to the petitioner to file necessary application before the DRT, Bangalore, as per section 17 of the Act. All contentions are kept open. So this was not seen. May I have produced 3 judgments of the apex court, my lord, in support of my contention. May I request my lord to kindly see the first one, that is the Matthew Varghese. I have furnished these judgments, my lord. Request my lord to kindly see. I have paginated as well. In page 1, in the head note 1 itself, their lordships have made it very clear that the rigor of law cannot be relaxed and the drill of the provisions of these rules has to be mandatorily followed. Securitization, section 13 and 36, sale of secured asset by secured creditor under SARFAESI Act, mandatory strict compliance with prescribed procedure, 30 days clear notice to borrower of date of sale, mandatory requirement of adjournment, postponement of sale for a period of more than 1 calendar month, no sale or transfer of secured asset to be made on any subsequent date without notifying borrower afresh with 30 days clear individual notice of the fresh date of sale. Any sale or transfer of secured asset under SARFAESI Act in violation of any of the above mandatory requirements held would be invalid. I request my lord's attention to para. I may not take much time of my lord. Para 26, 31, 53 and 55 of this judgment, because it is very lengthy. It runs to more than 30 pages.
26.
26, 31, 53 and 55 paragraphs of this judgment, madam. May I invite my lord's kind attention to internal ink page 10 of this judgment, madam. Sale or transfer of secured asset cannot take place without duly informing the borrower of date and time of such sale or transfer. Under Rule 8691, borrower has to be served with clear 30 days individual notice for sale or transfer of secured asset. Such individual notice is required to enable borrower to take all effort to retain his or her ownership by tendering dues to secured creditor before the due date of sale. Any sale or transfer effected without complying with the statutory requirement would be a constitutional violation and would nullify the ultimate sale. Securitization so-and-so 13.8. Debt financial. Expression 8691. Expression or used in 9.1 held should be read as and hence prior to sale of immovable secured asset, 30 days clear notice to public as well as 30 days individual notice to borrower has to be ensured. This has not been followed by DR 18. The second judgment, may I request my lord to come to ink page 43. Canara Bank versus Amarinder Reddy, my lord. Judgment of the Apex Court. May I invite my lord to para 14. This also speaks about granting clear 30 days time. The only restriction is to give 30 days time gap between notice and the date of sale of the immovable secured asset. Para 14, last two lines. Then the third judgment, my lord, where their lordships have held that the drill of the provisions of this act has to be strictly complied. This is, I have produced the copy downloaded from the Supreme Court website. It is in 2019 2 SCC, page 198. 2019 2 SCC, page 198. Hindon Forge Private Limited. Here, I request my lord to kindly see ink page para 19. Ink page 109. Line 8. Ink page 109, line 8. May I read, my lord? We are of the view that this argument has no legs to stand on the reason that banks and financial institutions can recover their debts by selling properties outside the court process under SARFAESI Act by adhering to the statutory conditions laid down by the said Act. It is only when such statutory conditions are not adhered to that the debt recovery tribunal comes in at the behest of the borrower. It is needless to add that under the Recovery of Debts Act, banks, financial institutions could not recover their debts without intervention of the DRT, which the SARFAESI Act has greatly improved upon. The only caveat being that this must be done by the secured creditor following the drill of the SARFAESI Act and rules made thereunder. Therefore, I beg to submit that the rigor of the law cannot be relaxed. Here, there has to be a strict compliance of the provisions of the Act and rules, which has not been done by KSFC. And the manager could not himself, given the valuation report, to suit his convenience and sold the property. In fact, one more factual aspect which I may be permitted to bring to my lord's notice is during the DRT hearing, in fact, I volunteered to pay the money, and also and I have also filed before my lords the checks that I produced before the court, my lord. That's also just to establish my bona fides, I produced the checks before the DRT that also have produced, my lord, here in page 56, 57, 58, to show that I wanted to clear the loan. Even today, I am interested to clear the loan.
What is the amount?
My lords,
What is the amount total?
about 2 crores as on today. I'm ready. I'm ready to clear the loan.
2 crores 22 lakhs 13,699.
Yes, I'm ready to clear the loan.
As
And
on 2019.
to establish my bona fides, because there was a talk of compromise, the intervention of the honorable member of the DRT, I also produced these checks. And it was filed before the court.
My lord, 2 crores 22 lakhs 13,699 as on 21st October 2019, my lord.
What is the amount as on today?
My lord, as on today, my lord, I'll get it, my lord, in a few minutes, my lord, before I'll get it.
So these acts of the KSFC would clearly indicate and demonstrate, my lord, that they have thrown all these rules into the winds. And the DRT order clearly indicate and demonstrate the nature of illegalities committed by KSFC in ignoring the provisions of law. And the DRAT says they're all technical. It accepts that there are irregularities and illegalities which are incurable.
Got it.
What is the value
Yes,
for which it was sold? Mr.
Grateful,
Dalal?
man. Grateful.
What is the value for which it was sold?
38 lakhs. I'll come back on this.
One property was sold, my lord. There are two properties. Only one property was sold for an amount of 35 lakhs 70,000.
Page 44, my lord. I have produced the sales certificate. It is at page 46, line 3.
Irrespective of the sale at 35 lakhs and odd, you are willing to pay now whatever the amount is due.
But I will negotiate with them and I will sell. I will pay, my lord. I'll pay.
Negotiate or pay?
In the sense because their rates of interest are exorbitant. A lot of the KSFC rates are extremely exorbitant. It is not like nationalized banks. They go for all kinds of compounding. I will negotiate, I will pay.
Lord, it is a contract which has been entered into. The question of negotiation, my lord, may not come.
I will pay, man. I want to save my property. I will pay.
Yes, Mr. Who appear?
Yes, Lordship, I am appearing for the purchasers, my lord. Here, your Lordship can say, admittedly has received the loan in respect of two properties.
That's fine.
2002.
That's all right. I mean, he's not denying that.
Yes, madam.
Then your property has been
Then
sold.
your Lordship can see first notice was sent on 9/10/2010.
Would you like to argue first, or would you permit the bank to argue? Because bank essentially has to defend its action, no?
Like if bank lawyer argues, no problem. Otherwise, I will argue, my lord.
We will hear you definitely.
Please.
So yes, Mr.
Yes.
Who appears?
Lord, I appear, my lord, for the cases.
Yes.
My lord, 13-2 notice was issued on 21/5/2010.
32 notice was issued on
21/5/2010.
21/5/2010.
Yes, my lord. 13-4, my lord, possession was taken on 6/8/2010. My lord, subsequently, my lord, we have brought to the notice of the owner of the property, my lord, by letter dated 10/8/2010, that the property has been taken, possession has been taken, and 30 days time has been granted to him, my lord, to repay the amount. The fact, my lord, that we have taken possession, my lord, was also published in the paper on 22/10/2010.
So first notice of sale was issued on 9/10, right?
subsequently, my lord, yes, my lord, on 9/10/2010, my lord, we have issued a notice.
What do you say? Who valued this property?
My lord, the valuation, my lord, was done by, according to us, my lord, he is an authorized officer. It's done by the KSFC official only, my lord, but he's an authorized officer.
Therefore, we get it.
He's a approved valuer, my lord.
Approved valuer of
KSFC, my lord. My lord, since, my lord, there was no, my lord, no amount was paid by the mortgager or the loanee. We brought the property, my lord, for auction on 9/11/2010.
No, but sir, approved valuer has to be as per the act, right?
Yes, my
Who
lord.
is an approved valuer?
My lord, it has been defined, my lord,
Rule 2.
Yes.
2D, my lord. 2D.
2D. So, person registered as a valuer under 34 EG of Wealth Tax Act,
yes,
approved by Board of Trustees. Is he there? You are saying he was your approved valuer.
Yes, my lord.
Fine. What else?
My lord, before going into the merits of the case, my lord, first submission I would make is that, my lord, the sale certificate, my lord, was issued on 23/12/2010.
Certificate.
23/12/2010. The appeal, my lord, was filed after 45 days on 6th February 2011.
7/3.
I'm sorry, my lord, the appeal was filed, my lord, on 7/3/2011. Sorry, my lord. The 45 days, my lord,
Ended on 6/2.
on 6th February 2011, my lord, it is over. Appeal is filed on 7/3/2011. My lord, section 17 clearly says any appeal, my lord, has to be filed within 45 days. And, my lord, no application has been filed by the appellant, my lord, to condone the delay.
So once it is adjudicated on merits, Mr. The delay is deemed to have been condoned. It was your duty to point
My lord,
it
there
out.
is no reasons, my lord, no discussions, my lord, to that effect.
This is what Supreme Court says. Supposing if a time barred appeal is filed,
yes, my lord.
the court does not pass any order on that application.
Yes,
no, the parties to before the court does not bring to the notice of the court the fact that an application is pending, and court passes an order. You were heard.
Yes, my lord. We
You
were
were
heard.
heard.
Yes, my lord. We were heard. We
Order
were
on
heard.
notice has been passed.
Yes.
So we can safely infer that delay, if any, was condoned.
Yes, my
So
lord.
that's it. Fine. Next, what?
My lord, the property was brought, my lord, for auction on 9/11/2010. And, my lord, in a paper publication, my lord, which was issued in Vijay Karnataka and Hindu, wherein, my lord, it was stated that the property can be seen, and, my lord, the e-auction process will go on from 15/11/2010 till 26/11/2010. We have, my lord, also issued a letter on 10/11/2010, my lord, to the owner of the property, my lord, asking him to bring any bidders if they are there.
When have you sold the property?
My lord, this property was sold, my lord, in the auction negotiation meeting on 3/12/2010. And, my lord, the same was communicated, my lord, to the auction purchaser.
Before 30 days, right?
Yes, ma'am.
Then what happened?
Yes, my lord, there has been some mistake, my lord, on the part of the KSFC in bringing it within 30 days.
Fine. Anything else?
My lord?
Anything else? Yeah.
Yes, my lord. Subsequently, my lord, on 7/12/2010, my lord, we have, my lord, informed the auction purchaser, my lord, to pay the balance amount of 26,77,000. When the property, my lord, was sold as 35,70,000.
negotiations.
Have to pay balance amount of how much?
26,77,000.
Okay.
And my lord, sale deed was executed on 23/12/2010 in favor of the second respondent.
Yes. Yes.
My lord, I would submit, my lord, since the sale has taken place in 2010 and the entire amount has been paid by the auction purchaser, my lord, at this stage, my lord, after a lapse of 11 years, this appeal, my lord, cannot be allowed. And my lord, the appellant, my lord, and the borrower had enough of opportunities and enough of time was granted, my lord, for them to repay the dues. Since, my lord, they have not taken any action, my lord, to repay the dues, we have brought the property for, my lord, auction and sold it in the public auction.
Yes. Yes, Mr. Hegde, anything else?
That's all, man. That is all.
Yes, Mr. Who appears?
Yes,
Lord,
yes,
for
your
the
lordship can say.
second respondent, Lord.
Let him, we'll come to you, Mr. Reddy. Second
Yes.
respondent.
Lord,
Yes.
I have got one submission, Lord. My lord, my lord, I am the auction purchaser, my lord, second respondent. My lord, the first sale notice, my lord, I want to urge only one point, my lord. 9/10/2010 is the first sale notice.
9/10/2010.
10.
Yes.
My lord, thereafter, my lord, the subsequent sale notice, my lord, 9/11/2010. My lord, the latest, my lord, Supreme Court judgment, my lord, in Karthik versus Subhash Chandra Jain, my lord, the Honorable Supreme Court, my lord, it has held that supposing if a first sale notice has been issued and thereafter in the second sale notice, if the 30-day period is not there, it does not mean the sale becomes void. That is the latest judgment, my lord.
What is citation?
My lord, citation I don't have. Karthik versus Subhash Chandra Jain, my lord.
Citation I have sent through email, my lord, today morning, my lord.
Yes, we have got it.
Please.
Which para?
Para 70, my lord. 70.
70.
Please, my lord. Page 70, post lines, my lord. May I read, my lord?
Where is it pleading that the first sale could not take place due to the appellants or petitioners in this case? Yes, Mr. Yes, please.
The senior advocate wanted to speak.
Yes, your lordship will see. I think.
No, let us hear him. You first conclude.
Yes, my lord.
Ah.
Lord, your lordship kindly turn to that para 70, my lord, as we have already discussed herein. The facts in the case of Matthew Varghese and the facts in the present case are totally different. In any case, in view of the observations made in para 53 of the judgment of this court in the case of Matthew Varghese, we are of the view that since the sale scheduled on 27/2/2012 in pursuance of the notice dated 21/1/2012 could not be held on accounts of the reasons solely attributable to the appellant guarantors, there was no necessity to provide 30-day period in the second sale notice dated 9/7/2012, which was in continuation of the first sale notice dated 21/1/2012. Lord, here also, my lord, we have issued the notice, my lord. Notice was issued by KSC on.
Just a minute. Where is first sale notice and second sale notice? Which page?
Lord, your lordships will find that, my lord, at para 30 of the in page 30, my lord, of the DRAT order. Thereafter, bank issued first sale notice on 9/10/2010.
and second sale notice on 9/11/2010.
You want to see the sale notice? Where is it? Office page 41. Yes, first is page 40. 41. Sir. Where is the second notice?
Lord, this is the second notice, my lord, at Annexure E, page 41.
Annexure C, my lord, ink page 38.
You should have told us, Mr. Ravi Shankar, you did not. Did not mention the facts.
I'm sorry, my lord. I was expecting my friend to.
Yes, the respondent should tell the facts. Very good.
No, my lord. I'm sorry. My apologies.
All right. Yes.
Last line of Annexure C. The date is 8/11, published in Hindu on 9/11.
This is the first notice, right?
First notice is not produced, but it is stated that it is made on 9/10/2010. DRAT in ink page para 10, line 4, ink page 33.
About 31.
Para 10, ink page 33, line 4.
Where is first notice?
It is not produced, my lord, because I did not receive it. That's what the DRT says, that it is no notice at all.
May I make one submission, my lord? My lord, the DRT, my lord, which refers to the first notice dated 9/10/2010, is, my lord, in respect of the primary security properties. It was not, my lord, in respect of the properties in question. Therefore, my lord, yes, my lord, there has been, my lord, the property was brought for auction on the first occasion on 9/11/2010 itself.
Oh, so it was in respect of a different property,
Yes,
right?
yes, my lord. Yes, my lord.
So they should, your colleague should realize they are trying to confuse us like anyway.
I'm sorry, my lord, I should have brought that to the notice of the court. That it
Yes,
is.
yes. Yes, Mr. So that's all.
That's all, my lord.
Thank you. Mr. Reddy.
Your Lordship, again, see, I have a copy of the publication of the first notice, my lord. Wherein your Lordship,
do you want to contradict the corporation? Corporation says it is not in relation to the property.
the property is mentioned here. Property mentioned in the notice.
Where is it?
That they have not produced, but I have a copy of that notice, wherein it is clearly mentioned a measurement 105/80 actually Bhumi Agua, that is in Canada.
Mr. Reddy, is it the same property as in 9/11 or is it a different property?
That is the same property, my lord.
But Mr. Egde says it's a different property.
My instructions are that, my lord, officers are here who says that, my lord, the primary security was brought for sale and the property in question now was brought for sale on 9/11/2010, or that is only on the first occasion, and it was brought for sale. And my lord, yes, there has been mistake on the part of the KSFC, my lord, by not giving 30 days time, my lord, as contemplated. That is what is, my lord, borne out from the records. It is not, my lord, what I am trying to say. It is borne out from the records.
This property is concerned, it is the first notice, not the second notice.
Yes, ma'am. Yes.
So a 30-day rigor would apply in all.
Yes, my lord, that is my instruction, my lord.
All right.
And what is the amount due now, Mr. Egde?
My lord, has on 10/3/2020, my lord, 336.62 lakhs. 336.62. As on 10/3/2020.
2020 or?
No, my lord, 2020, my lord, is the last
which they have in the computer. I just verified, my lord, with the officer.
After Reddy.
The Lordship will say that para 12 of the DRAT judgment, my lord, at page 34, my lord.
No, what is your submission?
Submission, my lord, he is a bona fide purchase, my lord. He has paid 35 lakhs and 70,000 in the year 2012. Instead of paying that amount, then that time, my lord, I should have deposited in Bangalore, my lord. I have invested this amount. I should have get the 2 crores now. What is my mistake, my lord? They have put into action. Then subsequently, I participated. I have purchased the property for a 35 lakhs 70,000. I paid the entire amount. Because of that reason, my lord, DRAT has observed that I am a bona fide purchaser.
Yes.
Para 12 of the judgment, my lord.
Yes.
Then your lordship can see that even the DRAT has observed that para 8 of the judgment, my lord, a notice was issued because he called for the records. Para 8 at page 32, my lord. According to action purchaser, bank had issued a fresh sale notice on 9/10/2010. This notice was duly served on the borrowers, but some of them refused to receive it. While borrowers' guarantors failed to discharge their liabilities, then bank issued another notice on 9/11/2010 and brought the property for sale in e-action. The appellant was stood as a successful bidder, and the EMD amount of rupees 8,93,000 paid on 7/12/2010, and remaining amount was within 15 days. In surface appeal, main objections of respondent borrowers was that the property had been sold to lower valuation. Then once again, your lordship may kindly see the para 12, my lord. Here it is made it clear, after having an operative stock of the acts and intention of the parties, it becomes clear that appellant action purchaser is a bona fide purchaser as a third party. Non-availability of valuation given by approved valuer and having a gap of less than 30 days in publication of sale notice, and the actual sale will not vitiate the sale. In view of the facts and circumstances of the case, because of respondent borrowers have failed to challenge the sale deed, sale certificate within 45 days, and to fail to make a deposit of the due amount. Here, your lordship may kindly see from 2002 to 2021, he has not paid even a single paisa to the bank, or otherwise he should have deposited before preparing an appeal before the surface DRT. He has not deposited. Now, after lapse of several years, my lord, then after purchase of my property, my lord, that after 12 years, my lord, now he has come forward that is showing some DDs. DDs in the name of mine. He has not handed over the DDs also. But even your lordship can assume that I have paid 35 lakhs and 70,000. Then what is the interest of that amount, my lord? That will put you into great loss and hardship. Because the judgment is clear, my lord, that my learned friend referred. The judgment of the Honorable Supreme Court, that the 3 judges judgment, my lord, Karthik and others was Subhash and Jain and para 70, it is made it clear, my lord, even that the first notice is served, then second notice is not required.
Yes. But there is no material that first notice was served. No material. The first
Either the appellants or the bank has to be produced, my lord.
No, he is saying no, Mr. Hegde is saying this was in respect of a different property. His corporation stand on instructions.
That the one property made as a 2 properties, my lord, are different, the same measurement.
That's why we said that if you want to contradict the stand taken by the corporation, then you will have to produce that copy of that notice.
That,
one more submission can I make, my lord?
Yes.
My lord, when the matter was pending, my lord, before the DRT, the Honorable Tribunal, my lord, directed the appellants, my lord, the appellants, my lord, sought for an interim order. And they said that, my lord, they will pay the entire amount within 3 weeks. That was recorded. Subsequently, my lord, they did not pay the entire amount. No amount was paid. The order, my lord, was dated 16/10/2012 before the DRT, where, my lord, an undertaking was given, my lord, by the appellant borrowers that the entire amount will be repaid. Now, my lord, again, after almost 10 years, more than 10 years. Before this honorable court also, my lord, they say that, my lord, they'll pay the entire amount. My lord, that is the way, my lord, the borrowers are, my lord, acting. Therefore, my lord, I would submit, unless, my lord, they show their bona fides, my lord, by depositing the amount before this court or before the KSFC, my lord, their stand cannot be accepted.
Mr. Reddy.
That's all, my lord.
That's all.
Because, I invested the money. Now your lordship will say after 12 years, my lord, now this appeal is allowed and set aside the action sale, my lord, I will be put into great irreparable loss and injury, my lord.
All right. Thank you.
Please.
Number 28, Sri Karan Joseph, Sri M.U. Punacha.
I appear for the petitioner. I've only served copies on the respondent, my lords. No objections have been filed.
My lord, my difficulty, my lord, is working in Ireland. He said he's coming to India before the end of this month, my lord. Your lordship may have it in the first week of March, my lord.
The counsel for respondent number 1. Grace current is granted 2 weeks time.
Obliged, my lord.
3 weeks time to enable him to file objection.
Please.
Number 29, Sri Rajesh Prabhu K. Sri G.M. Anand.
I appear for the respondent in this case.
Rajesh Prabhu K.
My lord, I am here. My lord, I have some problem, my lord, domestic problem. My wife has slipped into the bathroom and injured her, and she is bedridden. In fact, I went to attend her. The problem is I want 2 weeks time at least.
Current counsel for the petitioner. You are petitioner?
Yes. My lord.
Right now, pray for adjournment on account of personal difficulty just after 2 weeks.
Please, my lord. Thank you. Oblige, my lord.
Number 30, Sri Ajay Kumar Patil.
Appearing my lord for the
Sri Venkati.
petitioners. Please, my lord. Please, my lord.
Ashok Nayak, Sri C.R. Gowde.
Your opponents are not there, Mr.
Mr. Gowli is there. Mr. Gowli is there. He is the main contesting respondent.
Oh, where is he? Not saying anything.
C.R. Gowde.
I am for respondent, my lord. R6, my lord. My series ended up in other court, my lord. I pay for 1 week time, my lord.
May I request?
For 1 week in the court.
No, my lord. 1 week, not today, my lord. Not ready, my lord. Next week, my lord. Next week.
Hey, so what are you? Your senior is not ready. Why are you not ready?
No, my lord.
No, you are not supposed to be ready, right?
My lord, in session, my lord, I take on next week, my lord.
May I make one submission, my lord? Please, my lord. There is an urgency because the last date for payment of examination fee is day after tomorrow. That is the 3rd of February. And the examinations are commencing on the 22nd of February. The college is not permitting us to pay the examination fee. Yes.
If you succeed, you will appear in everything. What they will not charge any fee from you. They don't want to charge. That's why they are seeking adjournment.
I lose. This is the final year examinations. I lose one academic year if I am not allowed to appeal. My lord.
It will be heard on 8th February, Mr. Patil. 8th.
But day after tomorrow is the last date. May I just seek my lord's indulgence for permission to pay the examination fees? Just payment.
Mr. Patil, if you succeed, you will be allowed to appear in the examination. That is a distinct.
No, here the issue.
Already, if your petition is allowed, don't worry about last date. That last date is not for the court, right? You are fully protected. You are before the High Court. Don't worry about last dates, right? We are competent to direct that they should permit you to appear in the examination. Don't worry. We have no manner of doubt about our powers.
So we have to prepare and study, my lord. One academic year we have.
What to do? You see,
I am only
our
seeking.
predicament, we are ready to hear today
Your lordship
also.
may have it on
But
Thursday.
what to do that other person? You tell us what to do with that man.
I am only.
He's saying his senior is not ready. He is not ready, and he is not supposed to read the file. That's what he's saying. What can we do? Tell us.
May I request?
He will then, the result would be, Mr. Patil, you have known, I have been sufficiently, I have been here for a long time, and we will be faced with an application for recall of the judgment on the ground that counsel was not available, the junior counsel was not instructed, and he was not ready, and order has been passed in violation of principles of natural justice. This is the ground in review petition we are telling you. So it's better no to take it on 8th.
No,
and
man.
Mr. on 8th, you don't appear. Counsel for respondent number 6.
Yes, my lord. Yes, my lord.
You don't appear on 8th.
Yes, my lord. Yes, my lord.
No, either you are ready. If you are ready, then only you appear. But don't appear like this.
Yes, my lord. Sorry.
You don't want.
Yes, my lord.
And you should, I mean, now all of you should be cautious.
Yes,
These
sorry.
proceedings are being live streamed. If accidentally your client sees your performance, what he will do? Huh?
Sorry.
No, please think about your future. Mr. Everybody, now this is a dangerous thing. This transparency, we welcome on our part, but you should also become cautious. This is being live streamed. Everybody is watching.
Yes, Mr.
And you are telling that I am not supposed to read it. So why you have become an advocate then?
Sorry, my lord.
Huh? No, why? I mean, your senior is not ready. You are telling in front of your clients, everybody, that everybody will now know, whosoever is watching these proceedings, that your senior is not ready.
Yes.
And you are telling that I am not supposed to read. What will happen? Why are you here then? Why are you practicing then? Tell us a good reason. Why should you practice?
No, just
if you are not supposed to read the case, then why should you appear before the High Court? Tell us. One reason, if you could tell us, how many years?
Sorry, my lord.
No, how many years of practice have you put in?
8 years, my lord.
8 years. In another 2 years, you will be qualified. Huh? As per the constitutional requirement. And this is your performance. Then supposing if you become a judge, what happens to the litigants? Huh?
Yes, sorry.
No, it's not. I mean, this not a this thing. Please don't smile. We are serious. That's why we are wasting so much of our time. We don't know. You will not improve. We are sure. But still, our duty to say something. You won't improve your mend your ways. You will be like this only. But this is unfortunate, Mr. And please, that's why we are telling you, don't appear on 8th.
Yes, Lord.
We will decide it. Don't appear.
Oh, yes.
May I make a request, my lord? He's saying counsel is held up in some other court.
It can be. On 8th here. Hey, you should feel happy. No? You have got a walkover. He said he will not appear on 8th.
Senior will appear, my lord. No, may I request for the 5th, my lord? 5th, my lord. Because of 5th, my lord, please.
5th is Saturday, Mr.
I'm sorry, 4th, my lord, or 3rd, whichever, because there is some urgency. That is the 3rd is the last day. If his counsel is held up in some other court, 3rd.
We are surprised with this, Mr. Despite assurance being given to you, you are doubting our powers.
No, I'm not doubting, my lord.
So do you think that respondents above law?
They are certainly not above the
law. And by fixing a cutoff date for payment of fees, you can be deprived of your right even if you are before the High Court. We don't think you should think so, right? Based on 8th of, he's saying next week what to do.
Very well.
We told you,
I'll leave it
for
at
it. The aforesaid prayer is opposed by learned counsel for the petitioner on the ground that the last date of deposit of the fee is day after tomorrow. Is what? 3rd of February.
3rd of February.
2022. Full stop. Needless to state that in case petitioner succeeds, this court can always pass an appropriate orders protecting the interests of the petitioner by way of indulgence. List on 8th of February 2022, it is made clear that in case that no further adjournment on any ground to the respondent shall be granted on the said date. List on 8th February 2020.
Obliged.
31, C.H. Rajshekar.
Lords, I beg to appear for petitioner in this case, my lords.
I appear for the respondent, my lord. I requested my learned friend to provide me a set of writ petition copies, my lord, because my party received only the summons copy, my lord. So they,
how much do you want?
I will, sir. I will.
my lord, adjourned by 3 weeks, my lord. I'll have to seek instructions from Mumbai, my lord. I'll also get ready in the meantime.
All right. Undertake to comply with. Undertake to supply a copy of memo of writ petition along with annexures to Mrs. H.R. Renuka, the counsel who enters appears, who has entered appearance on behalf of respondent. Just after she prays for it is granted 3 weeks time to enable her to file objections and to argue the matter just after 3 weeks.
32, Sri Pradeep Yesavkar, Sri R. Nagendra Nayak.
Yes.
My lord, I am appearing for the respondent. My lord, I beg to appear for the petitioner in this case.
Yes.
Lord, in fact, my lord, talks of settlement is, my lord, underway. In fact, last occasion, my learned friend also, my lord, submitted the same thing. My lord, may I request for, my lord, about 2 weeks' time, we'll try to solve this issue and report before your lordship.
Yes, Mr. Naik.
Yes, my lord, I have no objection because I told them we can.
Jointly pray for and are granted 2 weeks time to enable them to report settlement.
33, Anji Zulfikar, R. Nagendra Nayak.
My lord, I am appearing for the respondent. Dismissal has been converted into removal. Dismissal has been converted into removal, my lord. Only he will be entitled for terminal. That's all.
But who appears for the petitioner?
Zulfikar.
Yaman Nisar Ahmad.
Yes. These are 2 cases, 27 and 27.1. Addressed us in
Second.
Yes, 25192/2019. This writ petition. The petitioner inter alia. No, in this writ petition, the petitioner has said the validity of the order dated 15/5/2019 passed by the debt recovery tribunal, as well as order dated 18/11/2013 passed by the debt recovery tribunal. In order to appreciate the petitioner's challenge to the impugned order, two facts. Petitioner was the owner of property bearing Khasra number 200/195, HL number 195/602, vacant site measuring 115 to 170 feet, situated Kanya KARIYA village, situated at Dugamala Road, Chintamani, district Ballapur. The aforesaid property was purchased by petitioner number 1 and her husband on 15/11/2017. The respondent number 3 for financial assistance to the tune of rupees 27 lakhs for building and for constructing a building and for purchasing utensils for Messrs. Parameshwara Convention Hall to the extent of rupees 27 lakhs from KSFC, Karnataka State Financial Corporation, hereinafter referred to as the corporation, on 13/2/2002, full stop. Thereafter, Messrs. Parameshwar Rice Industries, namely respondent number 4, borrowed a sum of rupees 9 lakhs for purchase of machinery from the corporation on 30/2/2002 itself. Full stop. The corporation classified the account, the aforesaid loan account, as non-performing asset. Paragraph. Thereafter, the corporation, section 13 within bracket 2 of the SARFAESI Act, hereinafter referred to as the Act. Full stop. Petitioners were served with a notice under section 13 within bracket 4 of the Act on 6/8/2010. Full stop. Sale notice was issued for sale of the properties on 9/10/2010. The respondent number 1, an officer of the corporation, determined an officer of the corporation who is said to have been an approved valuer of the corporation, valued the property in question at rupees 35.60 lakhs. Thereafter, a sale notice was issued on 8/11. No, you don't say this 9/10. Sale notice was issued on 9/11, 8/11. So 8/11/2010. The aforesaid sale notice thereafter, the aforesaid sale notice was published, one sentence. Thereafter, the aforesaid sale notice was published in daily newspaper The Hindu and Vijay Karnataka on 9/11/20, and then on 13/11/20. Communication dated 10/11/2010 was sent by the corporation to the husband of the petitioner number 1, by which he was informed that date of e-auction is 15. That e-auction is scheduled to be held. E-auction of the property in question is scheduled to be held on 15/11/2010. The e-auction was held on 15/10/2010, and the corporation confirmed the sale of the scheduled property on 20th/11/2010. The corporation thereafter issued a sale certificate in favor of respondent number 2 on 20th/12/2010, which was registered before Sub-Registrar Chennai. Full stop. The petitioners asserting the aforesaid action in a writ petition, namely WP number 2811-12/2011. Full stop. A bench of this court, by an order dated 27/1/2011, relegated the petitioners to avail of the alternative remedy under the Act. Thereafter, a sale deed was executed by second respondent in favor of one Srimati J.S. Rathi and Srinivasa on 15/5/2013. The petitioners filed an appeal under section 17 of the Act before the Debt Recovery tribunal and sought the relief of setting aside the same certificate. The aforesaid appeal was allowed by the Debt Recovery Tribunal inter alia on the ground that as mandated under Rule 9 within bracket 1 of the Security Interest within bracket Enforcement Rule 2002, the valuation has not been secured from an approved valuer as defined under the rule, and the sale has taken place before expiry of 30 years, which is violation of the mandatory requirement contained in Rule 9 within bracket 2 of the rules. Full stop. Allowed inter alia on the ground, right? Full stop. The respondents assailed the order passed by the Debt Recovery Tribunal in an appeal before the Debt Recovery Appellate Tribunal. The Debt Recovery Appellate Tribunal, by an order dated 15/5/2019, has inter alia allowed the appeal on the ground allowed the appeal area on the ground that on technicalities no party can be made to be benefited or suffered be it borrower, defaulter, or the auction purchaser. It was otherhead that the auction purchaser is a bona fide purchaser for a valuable consideration. Accordingly, the order passed by the Debt Recovery Tribunal was set aside. In the aforesaid structure background, this petition has been filed. Paragraph. Learned counsel for the petitioners submitted that the order passed by the Debt Recovery Tribunal suffers from an error occurring from the face of the record. It is further submitted that as per mandatory requirements contained in Rule 9 within bracket 1 of the Security Interest within bracket Enforcement Rule 2002, herein after referred to as the rules, the valuation was required to be secured from an approved valuer as defined under the Act, as defined under the rules, and the reserve value ought to have been fixed on the basis of the aforesaid valuation report. The said mandatory requirement has not been complied with in the instant case. It is also urged that there has been a violation of mandatory requirement contained in Rule 9 within bracket 2 of the rules in as much as the sale could have taken place only after an expiry of 30 days from the public notice. As referred to in Rule 9 within bracket 6 of the rules. Full stop. It is further submitted that on account of the violation of the that the sale has been conducted in violation of the procedure prescribed under the rules, and therefore no sanctity can be attached to the same in law. Submissions Remand has been placed on decisions of Supreme Court in Matthew Varghese versus M. Amrita Kumar, 2014, Volume 5, SCC 610, Canara Bank versus Amrinder A-M-A-R-E-N-D-E-R Reddy, and another 2017, 4 SCC 735, and Messrs. Hinton, Hindon, Ford, F-O-R-G Private Limited, and another versus State of UP, 2019, 2 SCC 198. The other hand, donate copy corporate on the other hand, donate counsel for the donate counsel for the respondent, donate counsel for the corporation, donate counsel for the corporation submitted that an approved valuer of the corporation had prepared the valuation report. However, it was fairly submitted that notice period that the sale was effected before notice period of 30 days. It is also submitted that in the facts and circumstances of the case, facts and circumstances of the it is also pointed out that sale certificate has been issued on 23/12/2010, and the appeal before the debt recovery and the limitation for filing an appeal before the debt recovery tribunal expired on 6/2/2011, whereas the appeal before the debt recovery tribunal was filed on 17/3/2011 without any application for condonation of delay. Therefore, the debt recovery tribunal erred in entertaining the appeal on merits. It is also submitted that even before the debt recovery tribunal, the petitioners had furnished an undertaking on 16/10/2012 that the entire amount due and payable to the corporation would be paid to them. However, till today, the amount due to the corporation has not been paid to it. Therefore, the conduct of the petitioners disentitles them any relief in the fact situation of the case. Paragraph. In the facts of the case. Paragraph. Paragraph. On the other hand, no, learned counsel, no, paragraph. Learned counsel for respondent number 2 has supported the submissions made by learned counsel for respondent number 2 as well as learned counsel for senior counsel for respondent number 4 and 5. 4 and 5 have supported the submissions made by learned counsel for the corporation and have submitted that they are bona fide purchasers for a valuable consideration. It is pointed out by learned senior counsel for respondent number 4 and 5 that aforesaid respondents have deposited the entire amount of sale consideration of 30.6 35.70 lakhs. Way back, huh?
35.75.
7? 35.30 point whatever 0.75 lakh way back in the year 2010. And it is further submitted that petitioners were afforded ample opportunities to repay the amount of loan. And therefore, at this point of time, no interference. At this point of time, after a lapse of 11 years, no interference is called for. Both sides and have the record. Before proceeding further, it is appropriate to take note of the relevant statutory provisions. Rule 2D, 2 small d, security interest, right? Relevant to take note of what? Relevant to take note of. So it is appropriate to take note of relevant statutory provision, namely security interest within bracket enforcement bracket code rule 2002. Then quote rule 2D. Then rule 9. Rule 85. 85 and 91. The 9. Thus, from the result of Rule 2D in conjunction with Rule 8 within bracket 5 of the Act, it is axiomatic that approved valuer means a person registered as a valuer under Section 34 AB, capital AB, of the Wealth Tax Act 1957 and approved by the Board of Directors or Board of Trustees of the secured creditor, as the case may be. Full stop. Rule 9 within bracket 1 mandates that no sale of immovable property in the first instance shall take place before expiry of 30 days from the date on which public notice of sale is published in newspapers as referred to in the proviso to sub-rule 6 of Rule 8, or notice of sale has been proviso to sub-rule 6 of Rule 8, or notice of sale has been served to the borrower in the backdrop of paragraph. The affected statutory came up for consideration before the Supreme Court in Matthew Verghese versus M. Amrita Kumar Supra, wherein the wherein it was held that sale of a secured asset by the secured creditor can only be made after strict compliance with the prescribed procedure. It was further held that the requirement of giving 30 days clear notice to the borrower with regard to date of sale is a mandatory requirement. Full stop. Similar view was taken by Supreme Court in Canara Bank Supra, and it was reiterated that 30 days time gap between the notice and the date of sale of secured assets is a must. In so and so was 2019 last year. In Hindan Forge Private Limited, it was again reiterated. It was again reiterated that banks and financial institutions can recover their debts by selling the property under the Act and the rules only by adhering to the statutory conditions laid down in the said Act. Paragraph. Thus, full stop, continuation. Thus, from aforesaid pronouncement of the Supreme Court, it is axiomatic that if a sale is held in violation of the mandatory statutory requirements contained under the Act and the rules, the same is vitiated in law, and no sanctity can be attached to such a sale. Paragraph. In the backdrop of quoted statutory provisions and the decisions referred to supra, we may advert to the facts of the case in hand. Admittedly, in the instant case, a sale notice was issued on 8/11/2010. The aforesaid notice was published in daily newspapers, namely Hindu and Vijay Karnataka, on 9/11/2010. The 9/11/2010. Admittedly, an officer of admittedly a valuer of the corporation had determined the value of the scheduled property at 35.60 lakhs. So the approved valuer of the corporation, not an approved valuer as defined under Rule 2 within bracket small t of the Security Interest within bracket Enforcement Rules 2002, read with Rule 8 within bracket 5 of the rules. Full stop. Thus, before effecting the sale of immovable property, the authorized officer has not obtained the valuation of the property from an approved valuer. Therefore, the inevitable conclusion is that the sale has been held in violation of Rule 8 within bracket 5 of the rule. Similarly, Rule 9 within bracket 1 of the rule requires that no sale of immovable property shall take place before expiry of 30 days from the date on which public notice of the sale is published in the newspapers. In the instant case, the notice was published in the newspapers on 9/11/2010, whereas the auction was held after a period of 6 days from the publication of the notice, that is on 15/10/2010, and the same was confirmed on 20th/11/2010. Thus, the mandatory requirement of providing 30 days notice to the petitioners as contained in Rule 9 within bracket 1 of the Act has also been violated. Full stop. Thus, full stop. Therefore, the sale is held in sale of the secured asset in question has been held in violation of the mandatory requirements contained in Rule 8 within bracket 5 as well as Rule 9 within bracket 1 of the rules. Full stop. Therefore, no sanctity to the sale can be attached. No sanctity to the sale can be attached in the eye of law. The same is therefore held to be vitiated in law. Paragraph. At this paragraph, the respondent number, respondents 2, 4, and 5. 3 and 4. Respondent number 3 and 4 are respondents number 3 and 4 are auction purchasers for a valuable consideration. The aforesaid respondents had deposited the amount of rupees 35.75 lakhs. 35.75 lakhs with the corporation way back in the year 2010. The corporation has utilized the aforesaid amount full stop. Since we have held that no sanctity can be attached to the sale in question, therefore the corporation is bound to refund the amount of sale consideration to respondent number 4 and 5 along with an interest which is quantified at the rate of 6% per annum. It is therefore directed that the corporation shall refund the amount deposited by respondent number 4 and 5 towards sale consideration of the secured asset within a period of 30 days from the date of receipt of certified copy of the order passed today, along with interest at the rate of 6% per annum from the date of deposit of such an amount till the payment is made to respondents number 4 and 5. Paragraph. At this stage, full stop. It is at this stage. It is noteworthy to. It is apposite to take note of the readiness and willingness shown by the petitioners to repay the entire amount of loan. Full stop. The aforesaid statement made by learned counsel for the petitioners is taken on record. It is directed that corporation shall indicate the amount due and payable by the petitioners to them within a period of 2 weeks from the date of receipt of copy of the order, and it will be and the petitioners shall make an endeavor to settle the accounts expeditiously, preferably within a period of 1 month from the date of receipt of such an offer. Needless to state that in case the petitioners fail to pay the amount as directed above, it will be open for the corporation to proceed against the petitioners in accordance with law. Say no sanctity can be attached to the sale of paragraph. For the aforementioned reasons, the orders passed by the order dated so and so, passed by the debt recovery tribunal as well as the debt recovery appellate tribunal are hereby quashed and set aside. In the result, the petition is disposed of in terms indicated above. The other thing is 27.1 for the reason assigned. Oh, 27 is right. 27 is true. First paragraph will be same. I'll check. Yes. So the senior counsel for the respondent 4 and 5 no, has relied on a decision of the Supreme Court in so and so. One paragraph we should say somewhere that this is retroactive. Has relied on a three-judge so and so Karthik versus relied on opposite submission. Yes.
Second stage. There is not a second stage.
Not the second segment, corporation standards. Yes.
Whatever matter, number 18 is higher VLV, Sri R. Omkar, Sri Aslam Khan M.
It appeared, right?
Nobody.
First round. None for parties even when matter is called in second round, awaiting appearance. Hearing is deferred. Just after 1 week, it is made clear that in case no appearance is made on the next date of hearing, appropriate order shall be passed. Yes.
Number 26, the Pawan TN, the R. Omkar, government advocate.
Mr. Shashikaran Shetty, learned senior counsel for the petitioner. None for respondent number 2. Respondents even when the matter is called in second round, awaiting appearance of learned counsel for respondents hearing of the petition is deferred. It is made clear that in case no appearance is made on behalf of respondents on the next date of hearing, appropriate order shall be passed this after 1 week.
Number 33, the Ansi Zulfikar, the Ahmad Nisar Ahmad, the R. Nagendra Nayak.
None for petitioner even when matter is called in second round, Mr. R. Nagendra Nayak. Waiting appearance hearing. In case no appearance is made, appropriate order just after 1 week.
Final hearing, number 34, the M. Lava, the K.V. Arvind.
Yes, Mr.
May please, Your Lordship. My Lord, in serial number 34, 35, and 36, Lordship, they are VSVS scheme. In that, Your Lordship may consider closing 35.1, ITA number 583 of 2016. I have already sent a memo to the court officer. Your Lordship can close it on the same lines that Your Lordship have been closing. The remaining thing, we are awaiting the proper Form 3, my Lord. Your Lordship may give 4 weeks' time.
Many cases. All right.
Yes, my Lord, because this one case can get closed, my Lord.
Learned counsel for senior counsel 35.1. ITF 583 bar 2016. Mr. A. Shankar, learned senior counsel with Mr. B. Chandrasekhar, counsel for the assessee. Mr. KVR, Mr. Jivan J. Nirali. Oh, who appears?
Yes, ma'am. Jivan Nirali.
No, your name. Mr. Jivan Nirali.
Jivan Nirali is sick, my lord, that's why.
So what is Sridhar? PNC Sridhar, learned counsel for the review, learned senior counsel for the assessee has filed a memo of this court to withdraw the appeal on the ground that the dispute between the parties has been settled under Vivad Se Vishwas scheme. The aforesaid memo is taken on record. The appeal is dismissed as withdrawn. What is the order?
Disposed of, my Lord.
Disposed of. All right. File disposed of. So other cases remaining, Madam, 34, 35.2, 3, 4, right?
And 36.
Learning senior counsel.
4 weeks, my Lord.
Praise warrant is granted 4 weeks time. Yes.
Number 37, the A. Sridhar Murthy, government advocate.
I pay for the appellate, but I pay for 2 weeks accommodation on this matter. I pay for the appellate. 37, my lord, I pay for the appellate. 2 weeks accommodation.
Why?
But I want to, I may be permitted to file my synopsis as well as some citations in what we also consideration.
8 years.
Sorry, my lord.
8 years it's pending.
No, 2 weeks, my lord.
No, what we are trying to tell you, this matter is of 2013 and is pending before this court for 8 years. Now, sir, please understand these proceedings are being live streamed. What happens if your client locks in and says, until this you have convinced the client that this bench is not good and it's going to dismiss your appeal, then it can be so. I mean, please understand, this equally casts us the responsibility on us as well as the members of the bar. Anybody can log in. After 8 years, your client may ask you why you did not argue the matter when the court was ready to hear. What will you answer? Please be aware, it's being live streamed, these proceedings.
I'm aware, my lord. I'm aware, my lord. Just one option.
Then why? So you are asking for an adjournment in such a casual manner that as if this petition is of the year 21 or 2020, 8 years.
Please.
Why? Tell us a good reason why we should adjourn it. Why?
But there are certain citations, Lord, which I have to put for your lordships.
You could have sent, no, citations are being sent. Ask Mr. Shankar.
Yes, I know, my lord.
So then they are doing it. So if others can do it, you can also do it. You should have done it. What leads you to believe that, and you are so confident about it that on mere asking, the court will adjourn? Supposing if we say, no, we will not adjourn, what will you do now? Tell us.
Well, if your lordship does not wish to adjourn, but I will have to argue the matter. That is the.
So you are ready?
Yes, sure. No, my lord.
See, and you have ensured that the.
There are certain case laws. Sorry, my lord.
So argue next week, Mr. Next week.
But 2 weeks. 2 weeks.
Next week.
Please.
Mr. Non-correspondence. Awaiting appearance of learned counsel correspondence, hearing of the appeal is deferred. List in the next week.
Right.
38, the KV Arvind, the V. Chandrasekhar.
38 and 39, about 3 weeks time, my lords. We need to prepare a compilation and file it before the lords.
2014.
Yes, my lords. Unfortunately, there was a disruption. There was a major disruption. There was a major disruption in office. 5 of us tested positive, my lord. So we are just getting back on track. Today, in fact, I'm just attending office. The earlier occasion, I appeared on before your lordship from home itself.
All right,
First week of March, my lords.
Just wait. Mr. KV Arvind, Learned Counsel for the Revenue, Mr. V. Chandrasekhar, Learned Counsel for the Assessment, Learned Counsel for the SSC, praise for adjournment. This in first week of March 2020. 38 and 39.
Deeply obliged, my lords.
Yes. 40, CM Lover, KV Arvind.
40 ready, my lord.
Ready. Ready, Mr. Arvind.
Please, your
Ready, Mr. Arvind. Ready.
Please, my lords.
40.
Please.
Yes, Mr. Mr. Shankar, please, word.
Yes, my lord. My lord, apart from the paper appeal memo, I also filed in this morning a synopsis and a case law compilation.
Yes.
Your lordship may also request the court officer to give the case law compilation and the synopsis I have filed, my lord.
Yes, we have got it.
Yes, my lord. Yes, my lord. So that it becomes easy when I refer to it, my lord.
Yes.
My lord, this is an appeal for the assessment year 2008-9. And the two issues that are arising for your lordship consideration. First, validity of reopening. Second, on the merits, whether the capital gains assessed by the assessing officer is for the assessment year 2008-9 or 2009-10. The assessee's contention is it is accessible for 2009-10. The revenue has taken a position that it is accessible for the assessment year 2008-9. Effectively, these are the two issues, and your lordship will get the questions of law at page 19. Question of law number 23, para number 23, first question of law is regarding the reopening of the assessment, and 24 and 25 together constitute at page 19, my lord. Not 23. 23 is para number, page number is 19. Page 19, 23 is for the reopening, and 24 and 25 is regarding the merits of the matter on the accessibility of the capital gains. I will first take your lordship through the reopening. Your lordship, in this regard, your lordship will take to page number 43. 43, my lord. Page number 43. 43 is, lordships may consider first taking page number 40, my lord. 40. 4 zeros. Next we'll take to 43, my lord. Page number 40. Is the notice issued under 148 for reopening the assessment. For reopening the assessment, a notice has been issued dated 16/7/2010 in respect of the assessment year 2008-9, issued by the Income Tax Officer, Ward 1, Puttur. Now, your lordship are aware that when a notice under section 148 is issued, the assessee has to file the return and ask for reasons, and then he can proceed with the matter with reference to challenging the very initiation of the reopening proceedings. In this regard, after filing the returns, which are at page 41 and 42, which are not very relevant, we sought for the reasons, and the assessing officer was pleased to grant the reasons, which your lordship will get at page 43. Now at 43, your lordship will notice reasons recorded for reopening the assessment procedure under section 147 by issuing 149 is as under. This is precisely the reasons he is giving. The assessee Shri Wilfred D'Souza has received payment of 30 lakhs in financial year 2007-8 from Shri Rohan Monterio as per Memorandum of Understanding dated 1/10/2007. On verification of records, the assessee has not filed return of income for assessment year 2008-9 till date. Therefore, I have reason to believe that the income chargeable to tax has escaped assessment within the meaning of section 147 of the IT Act. The only reason he has written is that he has information that I have received rupees 30 lakhs from Ontario. A payment, your lordship will notice the important words, because I'll take your lordship to a few decisions of the Supreme Court which are on parity with the same line of reasonings, and the Supreme Court has actually struck down as not a very valid reason. The important thing has received a payment, but what is taxable under the Income Tax Act is the income and not the payment. Merely because some person receives payment on any number, unless there's an income embedded in it, unless the reason to believe postulate a situation of having income embedded in that payment, the question of issuing a notice and arriving at reason to believe does not arise. In this regard, may I take your lordship now? The only reasons said are that a sum of 30,000, the 30 lakhs has been received from some. There is no dispute. We have definitely received a sum of 30 lakhs on that. There is no quarrel on that. There is not a quarrel because MOU is there on record with him. There is no proposition. But recording these reasons alone whether constitutes valid reason to believe under the scheme of the Income Tax Act is the question that arises for your lordship consideration, as the Lordship for a moment now may take the provisions of the Income Tax Act, Section 148. The Lordship, it is at page number 1.965. Has your Lordship have the 21 Act, 1.965?
Yes.
As your Lordship are having the 1921 Act, I take a Lordship indulgence in not seeing the main provision down below, my Lord. 2.17 substituted. That will be relevant for our purpose. Because 21, a very major change took place in the provisions of reopening. So I am just taking your Lordship there. 147. If the assessing officer, Lordship got it, my Lord?
Yes, yes.
Yes, if the assessing officer has reason to believe that any income chargeable to tax is escaped assessment for any assessment year, he may, subject to the provisions of section 148 to 153, assess or reassess such income, and also any income chargeable to tax which has escaped assessment and which comes to his notice subsequently in the course of the proceedings under this section, or recompute the loss or depreciation allowance or any other allowance as the case may be for the assessment year concerned, hereinafter in this section and in section 148 and 153 referred to as the relevant assessment year. The proviso is not required as far as our case is concerned.
Yes.
Explanation 1 is not required. Explanation 2, maybe my friend may read it, so I thought I should read it to your Lordship. Explanation 2. For the purpose of this section, the following shall also be deemed to be cases where income chargeable to tax is escaped assessment, namely, where no return of income has been furnished by the assessee, although his total income or total income of any person in respect of which is assessable under this Act during the previous year exceeds the maximum amount which is not chargeable to income tax. B, C, and all other things are not relevant. Now, in this case, admittedly, I not filed the return, but my income chargeable to tax has not exceeded the maximum amount chargeable to tax, so I did not file the return of income. Now, the most important words your Lordship will get under page 1.965. Once again, the starting words. If the assessing officer has reason to believe, the most important thing, my Lord, is he must have reason to believe that income has escaped assessment. Otherwise, he cannot issue notice at all. It's settled position of law. I placed a few Supreme Court judgments in my compilation, which I'll take your Lordship to. Subsequently, my Lord, under section 148(2), which your Lordship will get it at page 1.968, the relevant old provisions, down below only your Lordship may see, subsection 2, the assessing officer shall, before issuing any notice under this section, record his reasons for doing so. So there is a statutory mandate for recording reasons. Now, admittedly, the assessing officer has recorded reasons. There is no quarrel on that position. The question is whether the reasons recorded by him constitutes reason to believe or not. Now, in this context, my Lord, I seek your Lordship indulgence in stating that there are three aspects in a judgmental attitude of an assessing officer as to whether an income, whether the assessing officer is satisfied income has escaped assessment, whether the income tax officer suspects that is income escaped assessment, or the income tax officer has reason to believe it has escaped assessment. There are three things the Supreme Court in the country has said. There are three aspects to it. If the ITO is satisfied, 148 cannot be made. If he suspects, 148 cannot be made. He has to have reason to believe. So reason to believe is sine qua non for initiating 148 proceedings under the Income Tax Act. Why I mentioned these three words, my Lord, is satisfied, suspect, and reason to believe. Reason to believe is stronger than suspect. Suspect is stronger than satisfied. This is how the case laws have evolved on the system. So if you are merely having, if the income tax officer is satisfied, it is not sufficient. The income tax officer suspects it is not sufficient, but the income tax officer must have reason to believe that income has escaped assessment. Now, in the context of this statutory provision and the case law which I intend taking to your lordship, whether the reasons recorded by the assessing officer, which I read at page 43, constitutes reason to believe. If it does not constitute reason to believe, the question of any further proceedings in the assessment does not arise. The sine qua non is it must constitute reason to believe. Now, in this regard, my lord, I seek your lordship indulgence in taking the case law compilation filed by me today. The statutory provision for this case on 148 is only limited to reason to believe.
Yes.
Lordship, I straightaway seek a lordship indulgence in taking the decision, because most of them deal with various aspects of it. First, I take your lordship to the judgment of the Supreme Court in Jorilal Brothers, Jorilal HUF, 88 ITR 439, page serial number 16 in my index and page 106. Lordship may go to page 108, my lord. Lordship got it, my lord, 108?
Yes.
In that, your lordship, see, after the 1, 2, 3, the High Court, our answer, before proceeding. Your lordship may notice from the words before proceeding, I will read, my lord. Before proceeding under 34(1)(a), that is prior 147, could be validly initiated, the income tax officer must have reason to believe, but the reason of omission or failure in the part of the receipt to make a return of his income under 22 of any year, or to disclose fully and truly material fact necessary for assessment, income, profits, and gain chargeable to income tax have escaped assessment for that year, or has been under-assessed or assessed as a too low rate, or have been made the subject matter of excessive relief under the Act, or excessive loss or depreciation allowance have been computed. The formation of the required opinion, very important, my lord. The formation of the required opinion with income tax officer is a condition precedent. Without formation of such opinion, he will not have jurisdiction to initiate proceedings under 34(1)(a). The fulfillment of this condition is not a mere formality, but it is mandatory. The failure to fulfill that condition would vitiate the entire proceedings. As held by this court in Shivnath Singh versus Appellate Assistant Commissioner, the income tax officer would be acting without jurisdiction if the reason for his belief that the conditions are satisfied does not exist or is not material or relevant to the belief required by this section. It is true that the courts will not go to the sufficiency of the reasons which persuaded the income tax officer to initiate proceeding under 34(1)(a) of the Act, but the courts will examine the relevancy of the reasons which persuaded the income tax officer to take proceeding under 34(1)(a). The formation of the required belief is not the only requirement. The income tax officer is further by section 24 to record reasons for taking action and obtain sanction of the Central Board of Revenue or the commissioner as the case may be. So the mandatory condition is recording of reasons. Now they refer to decision of the Supreme Court in Shivnath Singh, which I have placed it at item number 17 at page 110 over the page your lordship may see. Lordship may come to page 112. Go to 113, my lord. Page 113, the lordship will see after two small paras, my lord. Each para are three lines. Since nothing has been disclosed, from there, my lord, I'll read about 10 lines from there, my lord. Why I'm reading this is very important because, my lord, my case on recording reasons falls within the same type of reasons recorded which the Supreme Court has quashed. Since nothing has been disclosed, at page 113, my lord, since nothing has been disclosed, which was relevant for the purpose of finding out whether the income tax officer has any reason to believe that income profit gains of the assessee chargeable to income tax is escape assessment, we gave an opportunity to the revenue to produce the records containing those reasons. All that has been found in the records are reported in Form B made in connection with the starting of the proceedings under Section 34(1)(a). Each report relating to different assessment years, items 7 and 8 of this form relate to brief reasons for starting the proceedings, and whether the Central Board of Revenue was satisfied that it was a fit case for the issue of notice. Against item 7, it is stated reasons as per separate sheet attached. Against item 8, the Secretary of the Central Board of Revenue signed after writing yes, satisfied. The reasons for starting the proceedings given in the separate sheet may be fully reproduced. Very important, my lord, your lordship may notice this. For the reason hereinafter recorded, I believe the income, profits and gains earned by the assessee in his personal capacity and in conjunction with others and chargeable to income tax have escaped assessment, and the amount of such concealed income relating to the accounting years covering the period beginning the first day of September 39 and ending on 31st day of March 49 amount to or likely to amount to 1 lakh. The reason for such belief materialized as follows. That means there are two conditions. You have to also say that it exceeds a particular amount of rupees. The assessee who is or was at relevant time a managing director in about dozen limited companies along with Oberoy's is believed to have made some secret profit which were not offered for assessment. The assessee is believed to have received a sum of 22 lakhs from Oberoy's, and this sum or at least a part of which represents income has escaped assessment. In our case, your lordship saw the reasons recorded. 30 lakhs from one Montorio has been received. Here is a case where very clearly they are writing this sum or at least a part of this which represents income which has escaped assessment. A far more detailed reasoning has been evolved here, but still your lordship. Now, how the Supreme Court deals with it, down below immediately after that, my lord. It is abundantly clear that the two reasons which have been given for the belief which was formed by the income tax officer hopelessly fails to satisfy the requirement of the statute. In a recent case, Suganmal Rajpal was Chaliha, which came before this court, a similar situation had arisen, and under the direction of the court, the department produced a record to show that the income tax officer had complied with the conditions laid down in the statute for issuing of notice relating to escapement of income. There also, the report submitted by the officer to the commissioner and the later orders thereon were produced. In his report, the income tax officer referred to some communication received by him from the Commissioner of Income Tax, Bihar and Orissa, from which it appeared that on such creditors where the assessee were mere name lenders and the loan transactions were bogus, and therefore proper investigation regarding loans were necessary. It was observed that the income tax officer has not set out any reasons for coming to the conclusion that it was a fit case for issuing notice under 148 of the Income Tax Act 1961. The material that he had before him for issuing notice has not been mentioned. The facts contained in the communications which has been received were only referred to vaguely, and all that has been said was from those communications, it appeared the alleged creditors were name lenders and the transaction were bogus. It was held that apart from the report submitted by the income tax officer to the commissioner, it was clear that he could not have reason to believe that on account of the assessee's omission to disclose fully and truly material facts, income chargeable tax has escaped assessment. In her judgment, the law laid down with this court in the above case is fully applicable to the facts of the present case. There can be no manner of doubt that the word reason to believe suggests that the belief must be that of a honest and reasonable person based on reasonable grounds, and the income tax officer may act on direct or circumstantial evidence, but not on mere suspicion, gossip, or rumor. If the reason for his belief that the conditions are satisfied does not exist or not material or relevant to the belief required by the section, the court can always examine this aspect, though the declaration of sufficiency of the reason for the belief cannot be investigated by the court. There is no material or fact which has been stated in the reasons for starting the proceedings in the present case on which belief could have been founded of the nature contemplated in 34(1)(a). The so-called reasons are stated to be beliefs, thus leading to an obvious self-contradiction. We are satisfied that the requirement of 34(1)(a) were not satisfied, and therefore the notice which have been issued were wholly illegal and invalid. In the result, the appeal is allowed and the High Court and the judgment of the High Court is set aside. Now, my lord, it's a very important decision in which the reasons are by and large akin to what has been recorded in my case, and the court has held like that. Now, I take one decision of our court, my lord, which is also how even if an elaborate reasons is required, sufficiency is not examined. but it must lead to a situation where there is income. In the instant case, your lordship has, at the cost of repetition at page 43 of the appeal memo, all that they have said is I received a payment of 30 lakhs on financial year.
So your submission
I have
is
reason to believe
basically,
income.
your submission is basically that this payment is not an income.
This payment, according to me, the
Is
payment
not
is
an
not
income.
income. I'm not saying that, my lord. I'm saying that I will take your lordship to few other decisions which says, for justifying whether the reasons are there or not, the reasons and reasons alone must be seen. There is nothing more to be added, nothing more to be subtracted. Your lordship are fully aware of it. So this alone does not even contemplate there is escapement of income. 30 lakhs is not income. 30 lakhs is a part of consideration I received. I did a transaction for 2 crore 32 lakhs of rupees, which I'll take your lordship when I go on merits. And then out of it, 30 lakhs advance I received. So the question of anything embedded as income in this year does not arise. It embedded as income in the next year, and I have to file my return for the next year. The department has not taken that as the basis. They have recorded reasons like this. This does not constitute an adequate reason in terms of the law mandated by the courts in our country. I will take your lordship to 2-3 judgment of our High Court, which have elaborately discussed these aspects. Lordship may take our High Court decision, which is at page 52, my lord. It is one decision which has comprehensively dealt with a lot of decisions very exhaustively at page 52. My friend has referred to some decisions which have been addressed in it. I will reply if required after he addresses it, my lord. The lordship may take to page 20. I mean, page 56, para 20, my lord. Sorry. Page 56, para 20. Permit me to read 2 pages from here, my lord, which takes care of the entire gambit. This is one decision which has actually exhaustively looked into a lot of aspects of it. Para 21. As against the judgment, learned counsel for the SC has placed reliance on the following judgments of the various high courts and the Supreme Court. I will skip that para. Now I'll start reading from para 22 onwards, my lord, 2 pages. Please permit me, my lord. In the matter of Madnani engineering, it has been held by the Apex Court. Lordship got it, my lord? Para 22 at page 56. Point out that though I am just reading whatever has been reproduced, my lord, though these decisions are very exhaustive and I have placed some of them in the compilation. We may also point out that though it was contained in the writ petition, the ITO could have no reason to believe that any part of the income of the respondent has escaped assessment by reason of its failure to make a full and true disclosure of material fact. The ITO did not disclose in his affidavit any material on the basis of which it could be said that he has come to the requisite belief. All that the ITO stated in the affidavit was, he discovered the transaction of loan against security of hundies were not genuine, and the trades against the names of certain persons who were alleged to have advanced loans were bogus. It was further held that we are therefore not at all satisfied on the affidavit that the ITO had reason to believe that a part of the income of the respondent has escaped assessment by reason of its failure to make a true and full disclosure of the material facts. Now, next, my lord, Gujarat High Court in the case of Birla VXL. Why for holding such belief must be reflected from the record of reasons made by the AO. In a case where the AO holds the opinion that because of excessive loss or depreciation allowance, income has escaped assessment, the reason recorded by the AO must disclose by what process of reasoning he holds such a belief that excessive loss or depreciation allowance has been computed in the original assessment. Merely saying that excessive loss or depreciation allowance has been computed without disclosing the reasons which led the assessing authority to hold such belief, in our opinion, does not confer jurisdiction on the AO to take action under 147 or 148 of the Act. This court, that is our High Court, my lord, in the case of H. Narona, has held mere suspicion would not be sufficient for reopening the case unless there existed some other prima facie evidence to warrant reopening. My lord, in the case of Chaganmal Rajpal, which was referred to in the one of the decisions which I read, my lord, Apex Court will consider reason assigned by the AO in its inimitable way as held as under. Hence, proper investigation regarding the loans is necessary. In other words, his conclusion is that there is a case for investigating as to the truth of the alleged transaction. This is not the same thing as saying that there are reasons to issue notice under 148. Before issuing a notice under 148, the ITO must have either reason to believe or the reason or omission or failure on the part of the SC to make a return under 139 for any assessment year, to the ITO or to disclose fully and truly all material facts necessary for his assessment for that year. Income chargeable to tax is escaped assessment. That is very critical. Your Lordship will again see the reason there is not a whisper about any income chargeable to tax. Merely because a person does a transaction, it cannot lead to reopening for that year, or alternatively, notwithstanding that there has been no omission or failure as mentioned of information is possession, reason to believe that income chargeable to tax is escaped assessment for any assessment year. Next, my lord. Calcutta High Court, I'll skip, my lord, may not be relevant to the facts of this case. Now, your lordship, para 27, very interesting decision, my lord. For the Bombay High Court in the case of Hindustan Liver. It is needless to mention, it is very important, my lord, same at page 57, para 27.
Yes.
Can I continue, my lord?
Yes, yes, please. Yes.
It is needless to mention that reasons are required to be read as they were recorded by the AO. No substitution or deletion is permissible. No additions can be made to those reasons. No inference can be allowed to be drawn based on the reasons not recorded. It is for the AO to disclose and open his mind through reasons recorded. He has to speak through his reasons. It is for the AO to reach the conclusion as to whether there was a failure in the part of the SC to disclose truly all material facts necessary for assessment for the concerned assessment year. It is the AO to form his opinion. It is for him to put his opinion on record in black and white. The reasons recorded should be clear and unambiguous and should not suffer from any vagueness. The reasons recorded should be clear. The reasons recorded must disclose his mind. The reasons are the manifestation of his mind of the AO. The reasons recorded should be self-explanatory and should not keep the assessee guessing for the reasons. Reasons provided the link between conclusion and evidence. The reasons recorded must be based on evidence. The AO, in the event of a challenge to the reason, must be able to justify the same based on material available on record. He must disclose in the reasons as to which fact or material which was not disclosed by the SC fully and truly of the assessment year, so as to establish the vital link between the reasons and evidence. The vital link is the safeguard against arbitrary reopening of concluded assessments. Of course, that will not come to my case. Last part. The Supreme Court in the case of Indian Oil Corporation has held, but reason to believe is not the same thing as reason to suspect. I told your lordship three things. ITO is satisfied, ISO has reason to suspect, ISO has reason to believe. Unless it is reason to believe, question of invoking 147 does not arise. Now, coming to a single judgment of this court, which your lordship, in the case of A. Nagappa, where the reasons of the AO were elaborate, were reproduced, yet it proceeded to quash the notice against SSC under 148 of the Act. This order was the subject matter of challenge at the instance of the revenue in writ appeal number 928 of 1991 before the division bench of this court, which held as under. More than the additional director of IT report with the learned judge characterized as evasive and speculative, it is statement of reasons for reopening which is evasive and speculative. We find no basis thereon which could have led the appellant to entertain reason to believe that income chargeable tax is escaped at the assessment year. It is imperative that reason should have a rational and relevant nexus to the formation of such belief. We do not find such nexus. I will read this decision more elaborately, which I have placed, my lord. The Supreme Court had the occasion to consider this fact of the matter in Ganga Sarans, when it has dealt with the situation beautifully by holding as under. It is well settled as a result of several decisions of this court that two distinct conditions must be satisfied before the ITO can assume jurisdiction to issue notice under 147A. First, he must have reason to believe that income of the SC has escaped assessment, and secondly, he must reason to believe that such assessment is by the reason of the omission or failure in the part of the SC to disclose fully and truly all material facts necessary for assessment. If either of these conditions is not fulfilled, the notice issued to the ITO would be without jurisdiction. The important words under section 147A are reason to believe, and these words are stronger than the word satisfied. Lordship, this is what I was explaining to your lordship. Three words are used: reason to believe, reason to suspect, satisfied. Satisfied is probably, in my view, the weakest of the recording. Reason to suspect is far stronger than satisfied, and reason to believe is far, far stronger than satisfied and suspect. In my humble submission, my lord, the reasons as recorded by the assessing officer in the present case does not contemplate to bring in any reason to believe. It can be a suspicion. I got some 30 lakhs from somebody. There's no element of charge. What is the tax escape? What is the transaction? Nothing is there in the reasons recorded. And well settled law, reasons and reasons alone must be looked into by testing the validity of the mandatory conditions to assume jurisdiction for the purpose of 147 of the Income Tax Act. Now, my lord, para 31 of the judgment. In the light of the aforesaid judgment of the various High Courts and Supreme Court, we have examined whether there existed sufficient reasons for reopening the case against SC, exercising the power conferred on the AO under 148. The reason to believe have been reproduced by us as recorded by the AO. And I will take your lordship, it is there in the earlier pages, my lord. The same would show that he was not even able to find out a prima facie case with regard to the escapement in the meaning of 149 of the Act. For the assessment day in 93-94, in fact, no cogent and valid reasons have been assigned by the AO for reopening of the case. In the light of the above discussion, we have no hesitation to hold that there existed no material for reopening the case against SC. It is further pertinent to mention here that one statement said to have been recorded under 132(4) of the Act were withdrawn. Then there existed no material on record to warrant reopening the case against SC under 148 of the Act. If the very basis on which the reopening was ordered did not exist, there was no question of reopening the assessment. This material aspect of the matter has not been considered by the AO, who proceeded to direct the reopening of the case without there being a legally admissible evidence available on record. Thus, the very issuance of a notice in 148 of the Act is found to be illegal and absolutely without jurisdiction. Then 34 and 35 are the connected other matters. In this regard, may I seek your lordship indulgence in page number 53, my lord. Page 54 will be more relevant, my lord. Just to explain to your lordship how the reasons were recorded in that case. This decision has been very succinctly written, my lord. After discovery of the aforesaid documents, during the course of search and seizure, that is the case of search and seizure, still they said 148 cannot be invoked. The assessments were reopened by the Assistant CIT Investigation Circle 1 after recording reason on 5th October 95. The SC was thereafter issued notice under 148. For the assessment year 89, 90 and 1991, the following reasons have been recorded. The assessee has offered in the statement under 134 the interest income earned by him of so-and-so and also investment made him in fixed deposit for the assessment year 89, 90. In view of the above fact, I have reason to believe that interest income and investment made in the fixed deposit to the tune of so-and-so has escaped assessment within the meaning of 147. The lordship will notice here that there was a search. In that search, there was a declaration. Of course, that the declaration was being retracted, but still, in spite of it, they said this is not amounting to reason to believe. It can be only reason to suspect. In spite of a search and the admission by the assessee. Except for minor changes mentioned above, similar reasons have been recorded in the authority of assessment year 1991. However, for the assessment year 1993-94, the following reasons have been recorded. I have reason to believe that income chargeable take as assessment year so-and-so. Notice put up. So there's no reason at all. In this background, my lord, the court was pleased to accept the tribunal order of quashing the 148 notice and said that nothing that this is a judgment, my lord, which generally takes care of most of the decisions that are there on 148 up to that particular point of time. Now, my lord, I seek your lordship indulgence. I won't take a lordship to the writ single judge order, but the division bench order in Nagappa's case, which for very strange reasons has remained unreported for a very long time. At page 95, I have placed it, my lord. The single judge order is at page 76. And at 95 is the division bench order, my lord. May I take your lordship? At page 100, my lord. Page 100. The reason why I am saying, pointing these particular reasons, my lord, in spite of such elaborate reasons, courts have held that it had to be reason to believe. Yes, and it can't be reason to suspect or just mere. Page 100, my lord. Am I audible, my lord?
Yes, yes.
Page
Yes.
100.
Yes, please.
The last paragraph 100, my lord.
Yes.
The reasons for reopening. I'll read that
Yes.
because how they have recorded reasons and still they have, this court has quashed, division bench. The reasons for reopening have been placed on record and quoted by the learned single judge. They read thus. For the relevant assessment here, the SC has income from house property, income from flying buses, and income from business of Iraq sales. Under that Iraq business, the SSC had returned only a meager sum of rupees 22,801. But whereas the SC's true income will be very high, higher to the extent of about 7 lakhs and odd, as compared by the Assistant Director of Inspection, who has conducted the search. The full details of the same are as follows. Purchase of Iraq as admitted, 5,48,000, sales as admitted. The sales price as admitted works out to 10 per litre. It is seen from the consumption of Iraq strategic booklet published with the Karnataka excise authorities that for the period between 1776 to 31/177, for 7-month period, the total quantity of consumption of Iraq was 73,670 liters, and accordingly, the average per month works out to 10,520 liters. Adding this to the approximate quantity of Iraq consumption from so and so to so and so will be 73,670 plus 21,040, that is 95,71 liters. Taking the supply rate at 5.27, the cost of purchase would be so and so has been claimed. There is therefore an inflated purchase of 49,200. Local inquiries made reveal that the sale price of Iraq was rupees 17 per litre on an average, and then the total sales would then work out to 16 lakhs. Therefore, the sales figures admitted as per the return of income is only so and so. Thus, there is a suppression of sales to the extent of so and so. Further, for this period, the actual amount of the kist payable will be 2,79,000, but an excess amount of 3,01,000 is claimed to have been paid. Therefore, an under assessment to the tune of 6,94,000 as follows. I have therefore reason to believe that by reason of the failure on the part of the SC is to disclose fully and truly all material fact necessary for his assessment for the assessment year 77-78, the income chargeable tax is escaped assessment within the meaning of 147A, and accordingly, the board's permission is solicited for reopening the assessment under 147A. It was submitted on behalf of the appellant that these reasons with the report of the ADI show that the case of reopening was made out within the matter should be remanded to the ITO. This is the revenues submission, my lord. No, your internet was unstable. Something popped up, my lord. Sorry.
Oh, we are able to hear you.
Suddenly it came. Suddenly your internet connection is unstable.
So page
Technology we have to
105
still
is the
improve, my lord.
conclusion. 105
Conclusion,
is
yes, my lord.
the
Conclusion, my lord. Conclusion at page 105. More than the ADI's report. 105.
Yes.
More than the ADI's report. Lordship got it, my lord. 105 last para.
Yes, we are ready. Yes.
More than the ADI's, your lordship, more than the ADI's report, which is the learned single judge characterized as evasive and speculative. It is a statement of reasons for reopening, which is evasive and speculative. We find no basis thereon which could lead the appellant to entertain reason to believe that income chargeable tax is escaped assessment of the relevant assessment here. It is imperative that the reason should have a rational and relevant nexus to the formation of such belief. We do not find such nexus. With such detailed report, why I am highlighting this particular thing when I don't want to take your lordship and trouble your lordship by the single judge order was also elaborately written. The reason, my lord, is reason to believe in respect of reopening is a very fine-tuned terminology and a mandatory condition for reopening, and there should be a live nexus between the reasons and the reasons recorded and the belief he entertains and the information he has. All three has to be linked. And your lordship, if I just want to read without drawing your attention, the assessee Wilfred D'Souza has received payment of 30 lakhs in so-and-so as per memorandum of understanding dated so-and-so. On verification record, the assessee has not filed return to the state. Therefore, I have reason to believe. Merely because when a person receives some money of 30 lakhs does not mean there is income escaping assessment. There is not even one whisper in the reasons recorded regarding income. It is basically reason of a transaction, not reason belief of escapement of income. There is one thing called as information of a transaction is what they have written. They have not written anything about escapement of income in this, my lord. Next, my lord. Page number 22, my lord. Only 4 lines I will read because I read some portion out of it from our High Court judgment in Tippay Shetty. Para 6 at page 22. From the last word, the top part I read it, my lord. The important words under 147, there were 8 lines from the bottom, my lord. The important words under 147A are as reason to believe, and these words are stronger than the word satisfied. This I read, my lord. The belief entertained by the ATO must not be arbitrary or irrational. It must be reasonable, or in other words, it must be based on reasons which are relevant and material. Very important, my lord. Then last 3 lines. If there is no rational intellectual nexus between the reasons and the belief, so that such reasons no one properly instructed on the facts and law could reasonably entertain the belief, the conclusion would be inescapable. The I2O could not have reason to believe that any part of the income of the C has escaped assessment, and such escapement was reason of the omission or failure or so and so. And the notice issued by him would be liable to be struck as invalid. He refers to this and he reproduces the section income chargeable to tax as escaped assessment, what is contemplated in the statutory section which I read. In view of the same, my lord, my first submission in this regard is that the reopening is invalid in law and the entire thing could not have proceeded at all. In this regard, how the tribunal has dealt with this, your lordship may see. Appeal memo. Para 17 at page 38 may be taken. Page 38, para 17. That's how the tribunal has dealt it in a very cryptic manner. Before leaving, it would be inappropriate if you do not deal with the challenge of reopening. Admittedly, SSC filed no return for the input assessment here. Notice was issued since the AO was having a record an agreement entered with SC with Rowan Ontario. In such a situation, we cannot say it is only reason to suspect. AO had reason to believe that income escaped assessment. The reason has been clearly mentioned by him as well. Thus, we are of the opinion that the challenge reopening has no legs to stand. This is precisely what they have written, my lord. Your lordship, in a very cryptic manner, not taking the law on the point. And of course, they have noticed some of my submissions. Para 10 at page 27, they reproduce one briefly my submission and come to the conclusion, and they deal with the entire thing only on the other aspect of the matter. My lord, my friend has placed some decisions before your lordship. May I take 1 or 2 paras of the judgment are in my favor recently.
We continue, Mr. Shankar, after the break.
Yes, my lord. Yes, my lord. I was about to say that. Then I thought there is another 3-4 minutes. Deeply obliged for a patient hearing, my lord. I think it's visible to them. Yeah, I want them to. Important.